Dear guests, dear colleagues, dear participants, dear friends of arbitration, good morning and welcome to third edition of Bucharest Arbitration Days. After 2 years of pandemic situation, we have finally possibility to see each other and to talk face to face on arbitration issues. This edition will be in a hybrid format to allow many people to the possibility to participate. So many thanks for the technical support assured by Wolters, Kluwer, Romania. Thank you also Charter Institute of Arbitrators, Transnational Dispute Management, Young Romanian Arbitration Practitioners, and our media partners, BizLawyer, Universul Juridic, and Juridice. Thank you all for being here and supporting this event. This year, the key word of 2022 edition of Bucharest Arbitration Days is energy. All panels of the conference will address topics related to energy project and investment disputes with focus on infrastructure and energy projects, arbitration as a suitable dispute resolution mechanism for energy disputes, regional approaches to energy project and dispute settlement with focus on the EU energy market, the Energy Charter Treaty and its modernization process. In the last time, disputes from energy contracts generate an impressive number of commercial and investment arbitration cases. Last year, for example, more than 15% of ICC cases was represented by energy disputes. More than 40% of ICSID arbitration was related to oil, gas, mining, electric power, and other energy claims, and the number of Energy Charter Treaty cases continue to grow from two early 2000s to a total 145 last year, most of them concerning renewable energy claims. So the future development of the economy will be closely linked to the field of energy. The invasion of Ukraine by Russia Federation has further highlighted the strategic role of energy for the economy. Basically, for now, the biggest question facing world leaders is how to limit their energy dependence on Russia. After the at the European level, the Green Deal is the strategic document for transforming economies for a sustainable future. Dear friends of arbitration, this third edition of Bucharest Arbitration Day is bringing together leading names representing relevant stakeholders in the energy and dispute resolution field, as representatives of states, the EU Commission, regulatory agency, energy companies, council, arbitrators, and experts. This year, we have two special guests, Mr. Bogdan Chirițoiu, President of the Romanian Competition Council, and Professor Peter Cameron, Professor of International Energy Law and Policy, University of Dundee, our keynote speaker of third edition of Bucharest Arbitration Days. Welcome both to Bucharest and welcome to this conference. Now, let me introduce one of our guests, Mr. Bogdan Chirițoiu, President of the Romanian Competition Council. Competition Council play an important role in maintaining competition on the energy market, but I invite Mr. Chirițoiu to tell about this field. Mr. President, dear Bogdan, you have the floor, and thank you very much again to coming here for this event today.
Thank you very much, first of all, Stefan, for inviting me. He did not disclose, but we are former colleagues and are good friends. Yeah. And thank you, all of you, for listening to me for a few minutes. Happens many times in my profession that I'm surrounded by lawyers. So it's often that I'm the only non-lawyer in the room. That's, yeah, today it's usual from this point of view. So you listen for a few minutes to a non-lawyer's perspective on arbitration and energy. Energy takes a lot of my time recently, partly because I'm also in the board of the European Agency for Energy, so-called ACER, but also because my day job is as chairman of the competition authority, and we deal more and more with energy. Why that? Okay, well, antitrust, as the name says. Okay, Romanians in the room know better what we do, but for non-Romanians, okay, we're the antitrust agency, so of course we have our load of energy cases. With increasing liberalization of the market, yeah, we complement each other with the energy regulators. So less they regulate, more room there is for us to apply competition rules. But also we somehow unusual for EU. We're also dealing with state subsidies, and energy receives a lot of subsidies. The transition to new technologies that was mentioned by Stefan, and this decoupling from Russian energy sources, especially from Russian gas. All these things together will require a lot of interest from the government, yeah? Which means a lot of subsidies that we'll have to deal with. And finally, we took upon ourselves to read very largely our remit. Our mission, we understand it widely to mean a contribution to well-functioning of markets and lessen bureaucracy, reduce administrative costs and burdens for companies. And here we meet alternative dispute resolutions, yeah, like arbitration. That's why we are strong supporters of alternative dispute resolution. We're doing our share to promote it in Romania. We have new EU-inspired regulations coming into force concerning some unfair trading practices, yeah, which are somehow, I see it as a notch below the traditional abuse of dominance. Yeah, so whatever doesn't meet the criteria for the abuse of dominance, we are trying to tackle through this kind of new rules on unfair trading practices. EU has recently introduced them in digital markets last year. This year we are implementing or introducing them in the food retail. And if we'll have our way, if the governments will follow our advice, we'll soon, I hope I'm not scaring you, but you should be happy, your lawyers, yeah, so okay, more, yeah, there's more, more scope for, or more work for you to do, yeah. We'll try to introduce them in the whole economy, yeah, through government decree, which is hopefully will be approved in the next few weeks by the government. So in all these areas, we are trying to promote alternative ways to solve disputes. Why that? Okay, because for me, it's a way for the society to deal with conflicts in a cheaper way, in a more efficient way. It's a way to save money. And I think the work that the arbitration court of the Romanian Chamber of Commerce is doing an excellent job in this sense. I also suspect that for some of you or the clients you represent, it's also a way to deal with institutions that you are more familiar with and you may trust better than the traditional institutions. Yeah. Okay, for a number of reasons, having arbitration, having faster, cheaper ways to solve disputes, yeah, I think it's a bonus, it's a gain for society, and again, we'll do whatever we can to push these kind of practices in Romanian economy. So, in general, we're very supportive of arbitration. Then we come to particulars, yeah. We come to energy markets. Energy markets are indeed difficult topics, yeah, because they require a lot of investment. This investment over a very long time, yeah, makes time to make the investment, takes a lot of time to recover, to make profits, to compensate those investments. Of course, companies need predictability. They have to be able to count on the conditions in the market allowing them to recover these investments. The problem is that markets, like life, unfortunately, is not that predictable. It's very difficult to guarantee, to make sure that over the 20, 30 years time, conditions will not change. So that's why I'm saying I'm looking with some concern to this increased level of litigation concerning or arbitration disputes concerning energy, and I think we have to marry them, to marry the stability that we guarantee to investors, yeah, with some other rules, and also to incorporate the uncertainty that unfortunately exists in life, exists in economy. Nobody could have predicted, or very few people, except Putin, very few people could have predicted the war in Ukraine 1 year ago. So we have somehow to be able to incorporate this uncertainty in, we cannot wish it away. Yeah? So we have to find ways to incorporate it. Yeah? Again, giving companies as much predictability as is possible, but accepting that not everything can be predictable. We are many times asked by the government to give them advice to consolidate their case in front of arbitration courts, usually the non-Romanian, yeah, Paris or Washington. And many times it's about energy, it's about renewables, disputing the changes in the support schemes of the government. We've never, to my if my memory doesn't fail me, I don't think we've ever been asked by private parties, by people suing the Romanian government, to give them any advice or information. So it's always the lawyers of the government that rely on us or ask us for support. But the case that was most problematic to me was the Mikula case, which was not an energy case, but I think it's somehow relevant for the type of issues that we could face. For probably the Romanians know the case better than me. I'm a non-lawyer, yeah, again. But for those that are not familiar with the case, this basically was a conflict between investments, this predictability provided by the investment agreements, by which Romanian government promised that is going to protect investments of citizens from partner countries, and the EU rules on subsidies, yeah, what we call state aid rules. And there was at least an apparent clash between the arbitration on the investment treaty, or based on the investment treaty, and the Luxembourg court, or not the Luxembourg, the Commission interpreting the state aid rules. Unfortunately, for practical purposes, this case did not give us an answer, because the money issue was, strangely to me, resolved by Romanian courts based on neither exceed or, finally, neither on exceed nor on EU legislation, but of the European Convention of Human Rights. So somehow the court succeeded not to have a say on either the investment treaty on the EU rules, but move to something that's probably more familiar to the Romanian judges, the European Court of the European Convention of Human Rights, and the jurisprudence of the European Court of Human Rights. So we, at least in Romanian courts, we did not have an answer about this potential clash between arbitration and EU rules. But still, even if we pay the money, so again, for Romanian government, the matter, I hope is closed, because we paid a lot of money. But the legal case is still going on. Yeah, we still don't have the final word of the Court of Luxembourg. Yeah? So probably in the next few years, at least we'll have a European perspective about this issue. But again, Mikula was not an energy case, but raised interesting issues, and I think we'll deal with this kind of discussions in these kind of issues will come up in the future, probably in energy field. Yeah. So at least you in this room will probably have to handle this type of situations. And my plea, as somebody who's very, very pro-market for company, but also worked a lot of time for the government. Yeah. I've been working in public administration for quite a long time now. So I'm trying to marry the two interests, yeah, of business and the need to develop the country, to have investments, but also to allow some flexibility to administration to react to changing circumstances. Yeah? So that's my plea, to find somehow a way to marry these two concepts. And I expect Professor Cameron will tell me there's no conflict. Yeah? That we already do that. Yeah? Anyway, thank you very much.
Good morning. I have the privilege to introduce our keynote speaker, Professor Peter Cameron. A keynote speaker is a personality that does not require introduction. This is equally a cliché and a truism. Luckily for us, we have more than this. According to the peers' recognition, this is a quotation, not my own labeling, Professor Cameron is one of the world's leading authorities in the field of energy. He is both an experienced practitioner and an outstanding scholar. Professor Cameron is a barrister, qualified in England and Wales, Middle Temple, has acted in many cases as an expert in commercial and investment energy disputes. He is also on the ICSID list of arbitrators. On the other hand, he is a professor of international energy law and policy in Dundee. He is the director of the Center for Energy, Petroleum and Mineral Law and Policy. Amongst other treatises and articles, he is the author of International Energy Investment Law, The Pursuit of Stability, and as a spicy detail, his book, Oil, Gas and Mining, a source book for understanding the extractive industries, has been downloaded over 74,000 times, and it obviously represents a sort of bestseller in the energy field. If that was not enough, he has also become the vice president of the European Federation of Energy Law Association and chair of its scientific committee, and as of 2022, he accepted to take over the role of editor-in-chief of the leading journal, Global Energy Law and Sustainability. I could go on like this, and then I would prevent Professor Cameron to provide his keynote speech. Without further ado, welcome, Professor. Peter, you have the floor.
Thank you, Kuzmina. Can everybody hear me all right? Good, good. Very important first step. Well, thank you very much for those flattering comments. So it's a great pleasure to be back in Bucharest, although the last time I was here was many years ago and the city looked rather different. It seems to have expanded very considerably, grown a lot, and I can't recognize it at the moment. But I'm looking forward to having a tour tomorrow to see it in more detail. So thank you very much for the kind invitation. And thank you for these introductory remarks. I have been looking at international energy investment law in the last few years, and as you were hearing, energy disputes are quite common. There are many of these disputes, and I've always found them quite fascinating. that look at the diversity, the range of these disputes, because it doesn't matter which source of energy you're dealing with, it seems to generate disputes, whether it's nuclear energy, whether it's electricity, even shale gas, which we don't have really in Europe, and of course oil, gas, and others, and renewables. And just on that point, what we were also hearing is that energy projects tend to be long-term, and I think one of the interesting things about that is that while the projects are long-term and the financing is required to think about a long-term project, if you're a lawyer, your big concern, or people will ask you, people in the project will be saying to you, how can we make sure that the conditions on which we invest will remain stable over a very long time? And I think that challenge to the creativity of lawyers is a very interesting one, because over many decades they've designed different instruments to make it possible to try and keep those conditions as stable as possible. And that's the area that I've been looking at probably more in the last few years than I have been at EU law. But the organizers very kindly asked me to look at the topic of competition in energy markets, because they knew that I had written quite extensively in the past on this subject, particularly when I was linked to what was called what is still called the European University Institute in Florence, and had many happy years there organizing various symposia. So today I'm going to be focusing pretty much on competition in energy markets with a view to looking at the European Union. So there's not too much on arbitration, but I would note that there have been quite a number of energy disputes that have arisen in the European Union, which have led to arbitrations, not least the ones that I'm sure you're aware of, involving renewable energy. There was a time when everybody thought you're going to have energy disputes with those fossil fuels, which are currently not fashionable at all, but you won't have it with the very nice, clean, renewable energy. Well, that's been proven to be completely wrong. We've had many big arbitrations involving different kinds of renewable energy, many of these before the ICSID in Washington, D.C. And I've been involved in 2 of those cases, which obviously I can't talk about. So my views are those of an academic lawyer, and not those of a European Commission official. And some would say, as a Brit, I should be careful of what I should say on this subject, because we're no longer part of the EU. But I do think that we're all part of Europe, and for that reason, I think, in fact, that's been reminded, I think, in 2022, this year, that we're all part of one region and we have a common interest. So I'm going to be sharing my comments with you today. Now, the subject matter is actually very extensive. So I thought I'd try and find some way of framing this complexity to make it rather easier for you to digest, because I'm sure for some of you this is new, and for those of you for whom it isn't new, you may be more familiar with some aspects than others. So what I'll do is I'll do 3 things to different degrees. One is give you a kind of overview of what I see as the main trends over the past 3 decades, a long time. Then have a look at some of the key actions that have been taken with respect to competition in the energy sector, and then finally some comments on current trends, which are moving ahead rapidly, as you must have picked up from the previous speaker. In preparing this talk, I note that I was assisted by my former student, a German lawyer called
Dr. Henning Mathiesen, and I take pleasure in acknowledging that role. I've got a number of slides here, and I'm going to be skipping through those slides at some speed. I think the organizers will share them with you, so if you want to take your time, have a look at them later, that's fine. If you don't want to go over them later, that's all right too. I won't be offended. But anyway, you'll get them. So first one here, summary. Let me just go through this brief introduction. I want to come up with to say something a little bit unusual. Just to say there's three ages of competition interventions in EU energy markets, all linked to specific social and economic priorities. And then the next thing I'm going to do is say, are we now seeing the beginning of a fourth stage, a fourth age? First one is linked to the idea that bringing the energy sector within the scope of the internal market would bring about cost reductions, enhanced consumer choice, and less risk of abuse by established players. That was into a context in which there was almost no enforcement of competition law in the energy sector, because the energy sector was supposed to be special, supposed to be different. That was the first stage. Long time ago, nobody here, I'm sure, can remember it, but it was an important phase in this story. Second stage evolved out of the first, and it concerned an intensification of the competition drive with an unprecedented application of competition law to the energy sector. And also, very, very new, the establishment of a complete new set of laws at the European level to do with energy regulation. Excuse me. Third stage evolved out of this, and we could call that the clean energy age. It saw a series of adaptations to allow member states to support various forms of clean energy and initiatives to address climate change issues. And that implied, importantly, a tolerance of more state intervention in the energy sector than before. Am I pressing the right? There we go. Two assumptions in the background, just to keep in mind. Long-standing tension between the integrative measures in the EU project, that aim of an ever closer union, and member state control over the energy sector for strategic and for social reasons as well, pricing. This remains, it's always been important, it remains of fundamental significance. You can even see it in the treaty where energy is a shared competence. Very, very sensitive area of the economy in Europe. Second thing, competition has perhaps been the policy priority most challenged by this tension between integration on the one hand and sovereignty over energy resources on the other. And it's been challenged by the rise of new and very important policy aims for both the member states and the EU. Approach, just in case that notion of the ages seems a little bit odd, a long time ago when I was on sabbatical at Stanford University, I read this really interesting book by a historian called Grant Gilmore, and he talked about the ages of American law. So I borrowed this device from him, so I hope Professor Gilmore doesn't mind. Here we go. The first age, long time ago. For several decades, the competition law was not applied to the energy sector. Few complaints were made to the European Commission at that time, way back 1980s, maybe very, very early 1990s. Closed, monopolistic trade areas were prevalent. In Germany, for example, they had demarcation agreements which excluded certain areas from competition in energy supply, and exclusive concession agreements allowed the holder rights to use public land for energy supply purposes. Change started slowly. The court, or the European Commission, initiated certain violation proceedings under TFEU 258 against 4 member states. Court found in favor of the Commission, and the various closed supply areas were abolished as a result. Consensus emerged at the time, big controversy, again, because of this basic tension. A lot of states wanted as much national control as possible. Legislation was a more democratic approach to making a change in European energy law than applying the competition law to particular cases. Now, the result of all that was that you had the first body of energy law, European energy law, affecting mostly electricity and gas, called the first liberalization package, promoting a limited market opening and a limited form of third-party access by means of a legislative instrument called the directive. That was very quickly overtaken by events. These were very weak rules. They didn't last long. A second package came out which increased the market opening very fast and provided for a management and a legal unbundling of transmission and distribution. This time, directives and regulations, a more ambitious approach to the use of European law. Second stage, intensification of competition. Who is the king here? Competition. The market rules. Remember, dates 2005, 2006. What's significant about that? Well, 3 or 4 years before one of the most important events of all, the financial crisis. It wasn't there. It hadn't happened. This was the time when everybody, and I do remember at Florence, all these regulators we invited to meetings talked about light touch regulation. Let the market decide. We trust the market. Competition inquiry, very, very impressive use of competition law at the time. I think extremely influential. I know we had all this legislation, but the use of competition law at that time under a strong competition commissioner, Nelly Cruz, was really was very influential. They really made it clear to the electricity and the gas companies, change is now going to happen, whether you want it or not. And then they conducted an inquiry to gather data on a huge scale. So they were able to say, these are the facts. Look at those facts. You tell us that there's competition in the EU. We can tell you from the facts that there isn't. There isn't enough, and it's got to change. So this was really quite an interesting period. Then there was more regulation made. The legal instruments used were more diverse. A third package came about, built on changes already underway, initiating ownership unbundling, strengthening third-party access, and introducing a basis for a regulatory body, slightly weak body, if I may say so, but anyway, it was there, ACER. Weak, but very but influential and very worthy, and also regulations on the grid codes. So we move on. So that's age 2. 3. A very significant expansion of renewable energy was evident by the time that the third package was adopted. So while these measures were taking place, which were very clearly oriented towards market opening, promotion of competition, another objective was developing, which was about clean energy, which was not about market opening. It was not about the promotion of competition. It was a different kind of drive, but it was in parallel. Different starting time, but still it had become important by this time. The package was based on a less market-oriented policy, and it has changed the way that markets work, The volume of renewable energy presents challenges to regulators and grid operators that nobody had expected at the time. It's been fairly successful. Initially, a huge amount of financial support for these renewable energy, gradually declining, so that they've become more market-oriented as a form of energy, which is a big achievement for renewable energy. The overriding policy goal becomes clean energy and emissions reduction. Shift in priorities evident in the fourth liberalization package. Looking ahead, and I'm going to be accelerating a little bit in a moment, is there any evidence that a fourth age might be emerging? And that's something I'm going to return to in a moment. Priorities that are now emerging include diversification of energy supply and intensified promotion of renewable energy owing to the Ukraine conflict and related supply disruptions. At the member state level, government priorities are to restrain prices for affordability reasons, with schemes to claw back power market revenue or cap gas prices in a number of countries across the EU. And I've given you some examples. So we're seeing more of the state intervention now, for obvious reasons. So, continuing this theme, if you, and I'll come back to this in a moment, if you look at the December 2021 gas market proposals, there the aim is to reinforce regional cooperation. There's an emphasis on hydrogen and a planned gas purchasing platform. Question would be, to what extent are these going to be compatible with EU competition law? Well, we don't know yet. It's too early. But that's the question to think about. If you have a look at the internal energy market and ask, has it been a success to date? The geometry right across the Union is variable or asymmetric. Overall, this part of Europe here that we're in has been slower to reap the benefits of the internal market, but they've been there. And increasing interconnections and the development of more liquid and diversified markets should deliver improvements. So I'm fairly optimistic about that. If it were not for the fact that everything now seems to be very fluid. Now, in terms of specific interventions, this is the bit where I'm going to be very, very quick in order to ensure that we've got some time for questions. The specific interventions, the evidence of the Commission's activity, of its commitment to making changes is evident in merger control, in actions taken to deal with an abuse of a dominant position, so antitrust area, and also in state aid control. There are many cases that we could choose from that underline the scale of activity by the European Commission in this area. So what I've got in the following slides is pretty much just an illustration of the range of actions in these areas. So very quickly, let me point to merger control, given the case or an overview, another overview slide. Here, overview of actions. The Commission's carried out approximately 648 merger control proceedings in the energy sector up to 2019, according to the statistics that we gained from the website. 48 of them contain incidental provisions to make the concentration compatible with the common market. They may not be sufficient to address the competition concerns, but that's only 48 out of a very, very large number. One case of where there was a prohibition is that Portuguese case on the slide. Moving on, E.ON energy case for merger control, antitrust, actual or potential cartels or abuses of dominant position. From the website, 53 proceedings in the energy sector, 21 subject to formal antitrust decisions. And here are some examples there: Greece, Czech Republic, one from Romania, I think another one from Romania on gas connectors, interconnectors I should say, and then another interconnector case, Germany and Denmark. Then when you move on to state aids, I think that's quite an interesting area. It's not one I can claim to be extremely competent in, because it's a very complex area. The rules that apply over state aids have been influenced by various guidelines on state aids for climate, environmental, and protection and energy. And governments have had to take action to support the deployment of renewable energy, coal phase outs, and so on. So those rules have had to be about striking, they need to be applied in such a way as to allow a balance to be struck between a strict interpretation of the competition rules and energy policy goals that require some state intervention. Hence, these guidelines that have been introduced have been rather important, with a new set coming out very recently. What you've got in this slide and the next one is an indication of the balance that is struck, which I think is, some people don't think so, but I think it's reasonably successful, between state control and adherence to the competition rules. So I've got a very small number of cases there, as I've emphasized, in bullet point 1, which relate to Romania out of the total. And these have been 13 of these have been concluded by formal decisions. As I say, you've got these slides, you can catch up on them. So moving forward, I think we're now, let me now just, how are we doing? We're all right? Okay. I hope I'm not going too quickly. The what I wanted to do now is just look to the future. Conclusions and outlook. Bullet point 1 here. Does it appear that there is less and less trust in the market to deliver competition and its benefits? Are we seeing now the beginning of a fourth age of competition in the EU energy sector? And I'm really asking that question to you, but I'm going to give you a little bit of direction as to how I think one might approach it. This is very much a topic of the moment. I've got on the slide reference to the renewable energy power plan for the EU, but I would, before I say anything about that, I think I would rather instead give you another example. I've got two, this one, but also another one, of why I would be a little bit concerned about the way things are going with respect to the application of competition law. Firstly, going back a little bit earlier, if you have a look at the attempt by the EU to introduce changes in the gas sector, you find that they are currently proposing a common purchasing platform for gas. Well, that's interesting. And some of you might very well think, wait a minute, I've heard this before. Does this ring a bell? And others I'm sure will say, oh, no, it's very clear. Joint purchasing, that's illegal. We can't have that. We've all done competition law. We know that you can't do this. Well, they're both right. You see, let's look at this proposal. The European Commission has come forward with a proposal, one of many. Why? Because of events in Ukraine, mainly. To address the energy security issues caused by those events, the idea is to establish an EU energy purchase platform to secure supplies of gas, LNG, and hydrogen. Hydrogen, very important for the future. They haven't missed it. At affordable prices. And to phase out dependence on Russian gas. That's the point. Okay. A common purchasing platform, voluntary in character. Well, the aim is to use the EU's market weight, this is what they say, in making purchases from outside the EU, and also to coordinate member states in their gas storage practices for next winter, and to use gas infrastructure optimally. Well, one of the ways that it will operate is to consider expanded imports from the Caspian Sea area. Very, very loud bell now ringing. This, some of you will be aware of this. It has a very clear competition implication, joint purchasing of gas. And that bell, I would say, is about the so-called Caspian Development Consortium, the CDC, an idea which started from a summit in 2008, which proposed joint purchasing arrangements to support the development of new gas supplies in the Caspian Sea region, as well as from the Middle East, and to support the transportation of that gas to Europe through new pipeline infrastructure. The project sponsors at the time, the very 2008, 2010, thought that the consortium would achieve these objectives by aggregating demand for these new gas volumes and presenting suppliers with a single strong counterparty for gas sales into Europe. Maybe, in a sense, very sensible and practical to the people who thought it all out, not in terms of people sitting in the competition directorate in Brussels. Why had this not happened before? Well, the answer is because consortium purchasing is a practice which was once common in the European gas market, but for many years it has been prohibited under EU competition law. Could the consortium provide a framework under which competition issues could be addressed? That was the question. But it did go against the idea of a long-term trend to the liberalization of European gas markets. The idea by the apologists was that this is a temporary accommodation justified by the need to diversify European gas supply, and it was essential if a competitive market was to be obtained in the long term. Now, all of that was described in a report in 2010. In chapter 4 of that report, and I'll just wind up about that report now, but chapter 4 of that report describes how the competition laws would be addressed, going into Article 101.1 and 101.3 of the TFEU. I won't attempt to summarize those arguments, but the key point is that the consortium sought letters from the Commission. Not an exemption, but letters that would comfort it that this was okay. They wouldn't experience legal action. EC response at the time was, no. You can't have any such letters, that's it. Competition law is quite clear on this point, it's not allowed. And the idea came to nothing. That was then. Why is that worth thinking about? Not least because it's an echo of what we're seeing now, but where are we now? What is the context now? The answer is that at that time, the context was one in which competition law was paramount. That, I would say, is not the case now. I know you could say literally from a legal point of view, it's still there. Yes, that's right. But in terms of energy policy priorities, I don't think so. I might be wrong. I might be wrong. I can't prove it. So I'm just throwing that out to you, that we might have a different outcome this time. Those letters, if they are required, might well be forthcoming. You know, that's 12 years ago when the Commission said no, things might be different. Okay, moving on a little bit to the second example, the renewable energy power plan. In May of this year, the EU produced a communication on this plan, which I've explained in some detail in the slides. The aim is to reduce EU dependence on Russian fossil fuels by accelerating the clean energy transition and, quote, joining forces to achieve a more resilient energy system and a true energy union, unquote. It builds on the Fit for 55 proposals. Now, the language of this document is full of words like coordination, joint purchases, and planning. And it openly declares its aim as being to, quote, structurally transform the EU's energy system, unquote. It contains an interesting diagram on page 1. For those of you who are familiar with the so-called energy trilemma, some of you may have heard of that little diagram that was often in European policy documents: affordability, reliability, security. Well, this has as its corners of the triangle: accelerate the clean energy transition, diversify energy sources, and save energy. Slightly different. Under the triangle is the aim, quote, to smartly combine investments and reforms, unquote, at national and EU levels. Echoes of that joint purchasing approach there. This suggests to me that the policy priorities are shifting. For me, there are lots of questions emerging from this document which demonstrate much less trust in the market's capacity to deliver energy policy goals to consumers in the EU. So I'm not being dogmatic about this, I'm just raising questions that here's another example of what seems to be a case of moving into a new age. So in this context, just concluding now, in this context, will those member states which have been perhaps slow to embrace competition, will they now feel the need to push ahead with it? Another question would be, does this indicate a short-term trend, or are we seeing a shift back to the kind of world that I sketched out way back at the beginning, that first age, where energy is regarded as an exception to the scope of competition law? That's my second question. Third one, last one, on unbundling. On unbundling, this will come up with respect to hydrogen. And the question there would be, will the European Commission require it as a matter of principle or not? In the past, they've been fairly, stubborn is perhaps the wrong word, but they've been quite determined to commit themselves to the internal market principles. Will they do that with unbundling when it comes to hydrogen? Again, I don't know the answer yet, it's too early. So if the idea of a rollback to an earlier era seems dramatic, just look at the country that was once a market leader in promoting competition. Which country? Well, where do I come from? United Kingdom. And its attitude to, for example, to price caps is now opposite from what it had more than 20 years ago. It's reversed. Whatever it says, if it says anything to the contrary, don't believe it. It's changed completely. And so what does all this mean? Well, I suggest to you, just winding up, I suggest that the new approach that's emerging is indeed a pulling away from the market. Why? Because it appears that the private sector needs incentives to curb emissions and to build infrastructure for energy security that are not there. It needs incentives, they're just not there to get the market moving, or they're too weak to get the scale of intervention from the market that is required. How the reaction to that insight will work in the face of existing competition law and practice in energy markets is not clear. What is clear, though, is that the corners of that energy triangle, they're moving on here. Okay, never mind. The corners of that energy triangle that I mentioned that comes out in so many of these EU documents, each one, I would say, are spinning. They're moving around. They're very, very fluid. Which one is the dominant one, we don't know at the moment. And whether this is a long-term trend or a short-term response is also not clear at the moment. So that's the direction we're going, into some considerable uncertainty. But I think you can see, in my view, this is probably much more than a short-term set of responses. And indeed, we may be moving into a different energy paradigm in the European setting, and it's one in which the role of competition law is going to have to adjust. So that, basically, in a nutshell, is my view. I've spoken a little bit longer than I was supposed to. I hope that doesn't mean that I'm not allowed to have lunch. But anyway, I'm going to stop at this point. Thank you very much.
Thank you, Professor Cameron. We are slightly beyond schedule, but not because of the very interesting presentation that we witnessed. It's because we actually started a little bit later. We are supposed to have also a brief Q&A session, and I would think we should take advantage of the presence of our two distinguished guests and take at least 2 or 3 questions. Now, we have the technical possibility from anybody in the floor to address the question. A mic will come up and you can simply speak up and address the question. Are there any volunteers for the questions? If not, or until you warm up, I would dare to start with a question. And I start with a comment or with introduction. The backdrop of the energy market or energy sector as we used to know it was, as you nicely put it, the overriding EU policy goal becomes clean energy and emission reduction. This is what we used to hear. We also have the Paris Agreement and the COP 2026 Glasgow Climate Pact. That was the backdrop. Now the reality is that we have a war in Ukraine that unfortunately doesn't seem to stop immediately. We have a price crisis which is in full blossom, unfortunately, once again. On the other hand, we witness, I think, every 2 weeks a new package of sanctions that are being issued against Russia with a direct impact upon the energy market. And my question is in this context, and I come back to the general theme of our event, which is timely perspectives on the energy market. My very question is, for both of you, the following. As far as time is concerned, we are in the middle of a tsunami and hurricane on the energy market, and they are unfolding. This is a sort of intermediary situation that will one day end, but it doesn't. The factors that trigger disruption are there. And then in the future, we are going to have a permanent new reality. My question is, when and how should the legislators, EU and the member states intervene? Because I would expect them to intervene rather sooner than later, considering the unique context and reality that we are facing.
Then you have the last one, yeah. And I've used the opportunity to react a bit. Okay, two background points, and then I'll go to what's going on. I don't think ever competition in energy market, or the energy market, I don't think was ever a level playing field, yeah, because theoretically it's competition, but it's one source, and energy it's relatively homogeneous goods, at least electricity. But okay, some of the players in the market are penalized, yeah, because we have emissions, yeah, so they're supposed to compete, but okay, some producers are going to be penalized by taxes, excise duties, whatever, while some others receive subsidies, yeah. So it's always a bit of a rigged competition. I accept that normally when you think about competition, we think competition is not a goal in itself, yeah, it's a means to an end. Normally the end should be efficiency. Now we're talking not only about efficiency, but not primarily about efficiency, but we're talking about also climate goals. So, okay, we're still using, I would argue we're still using, and I'm going to use competition tools in order to achieve different objectives, yeah, to basically to get the transition, the climate transition, whatever, yeah, the Green Deal, whatever, yeah, at the lowest possible cost. And I think we're still doing this. The state aid subsidies, which are now being prepared, are moving, at least theoretically, we should not subsidize technologies which are already mature, which might mean those that we currently have in Romania. They might not require subsidies. And whatever requires subsidies is going to be contracts for, or largely will be contracts for difference, which in my mind, it's a more intelligent way of subsidizing things than the green certificates that we used to have, or we're still using in Romania. So I still see competition being used. And I think there's now going to what's gonna come. On one hand, I think we moved very, very slow. And I think the Commission is on the back foot. The countries are pulling in different directions, and you see the Council, yeah, having the discussion, including the European Council, having a leadership position on energy, or at least the discussion on energy, and the Commission, which is the defender of the treaties, yeah, defender of the faith. It's taken a back step, and DGNR, it's basically if you look at the toolkits, the recommendation they made to member states, they are vaguer and vaguer. They started last year saying you should not do X. Now it's, well, if you do X, there are some downsizes. If you do Y, there are some downsizes. So it's a bit of a la carte now, what is coming from the Commission. So yeah, I'm not very impressed with the leadership of the Commission in this crisis. But what I think is going to happen, yeah, we'll have internal market. We want competition in the internal market to lower costs. I fully support the Acer report. As I said, I'm sitting on the board, administrative board, okay, I don't have to approve their materials, but I fully support the report that Acer has presented last month. I think we need more interconnection. And I think in this sense, I believe we'll have more of an internal market. Already, if you look at prices on the spot markets, on electricity, there are not such huge variation between most member states. On gas, there seems to be more variation. So, but I think we're moving to an internal market. Outside, I'm not that troubled about this common buying when I have just one supplier. That's basic economics. If I have a monopson, then I want to have a monopole. Monopolist has to counterbalance the monopsonic. One seller, there should be one buyer. It's pretty stupid to have one seller and different buyers to compete versus one seller. So this joint buying, if it's about Russia, I don't see it as problematic. We've done it with vaccines. I think it was a good thing that we have this common procurement of vaccines during the pandemic. So I'm not struck as being unorthodox having this idea of common buying. For a medium-sized country like Romania, would be good. We do common borrowing now. We like that Romania does not have to borrow itself at high rates, and we all, Europe, borrow together money for the resilience program. Yeah, why shouldn't we buy Russian gas also together and try to countervail the market power that Russia has on gas? So I'm not troubled by Europe being more united outside. I still think we're going to have competition inside. We need it, and I think we'll have it. I'm indeed concerned about countries like Romania, which are backpedaling on liberalization. And I would love to see the Commission to be more forceful at imposing the rules of the internal market.
Well, thank you. That was interesting to hear. So you'd like to see the Commission being more assertive with respect to certain member states. Okay, I would cut through this, and I would say you could get you've got a short-term response and you've got a longer-term one. I think you mentioned the word slow. I would say you're going to get in the short term some quick responses to the current situation, rapid pricing, the need to diversify. Hence, you've got these measures that I've just mentioned, two examples about the gas purchasing and renewable energy, which will no doubt be refined and possibly dropped in the future. But they politically, you have to take action quickly because this is too big a crisis. You have to be seen to be busy. How profound those interventions are, that's another question, because they're being taken rather quickly. If you're on the competition side, my guess is that the word slow is operative, because there you're going to be looking at a very, very new situation and wondering what it means, trying to assess the significance of it. And I would have thought that the people in the various competition authorities, both nationally and at the Commission level, are going to be spending quite a lot of time discussing the implications for some time. So that I would have said was it's a sort of politically a fast response, but not necessarily profound. Intellectually, on the competition side, probably a slow response. I mean, competition law is quite deep, quite profound in the European body of law, and it always tends to attract some pretty clever people. I think there'll be a lot of slow reflection. Longer term, I don't know. That's the really interesting question. And nobody knows at the moment what is all this going to mean, because if I'm right in suggesting, and I can't do any more than that it's like a paradigm, a framework for energy that we have evolved over many, many years, which is now being challenged because it was based on some assumptions that are now not tenable. They're just, you cannot go to a gas conference and listen to somebody who says gas from Russia, it doesn't matter what Russia is like, but gas from Russia is always reliable. It will not be cut off. You would laugh. You can't, that proposition, which I've heard several times, is no longer tenable. And that, for some countries, especially Germany, is an enormous change, and you can't just within within a week you can't change your energy policy. This is ridiculous. And politicians do come out sometimes with these silly statements, but you can't make this change. But we might very well, and I think we are at the beginning of a new phase of thinking about European energy, and that will definitely have implications for national and European competition authorities. So I would have said there are two phases there. That's all I want to say.
Thank you very much for the answers. I don't see any other questions or intentions to address questions. I would have had some other questions, but I'm pretty sure it would qualify as monopolistic behavior, and I'm afraid of the sanctions the Competition Council may apply upon me. So we can conclude our panel. I don't know whether we are going to witness a fourth age that may be emerging. I'm pretty sure that our panel one will be emerging in 30 seconds here, and we'll go on. Until then, please join me in the round of applause for our distinguished speakers.
Energy lawyer with Volciuc-Ionescu, a law firm, a transactional law firm with a strong focus on the energy sector. I have the pleasure today to moderate this panel. We have actually an amazing panel here on regional approaches to energy projects and dispute settlement, the EU energy market. And we will be talking about the EU energy policies and decarbonization. We've heard a bit about that already this morning. Then we'll talk about the current energy crisis and some of the actions and measures that have been taken or are planned to be taken at EU level and also by member states or other European states. And then the last part will cover some of the energy disputes that are, on the horizon given the current context. So I will just start by introducing our wonderful panelists, and I will start on the left with Dr. Petra Nemechkova. She's a Czech and Spanish lawyer, born in Prague and raised between Czech Republic and Spain. She has been working with the European Commission for more than 12 years already. As a member of the legal service, where she deals now with intellectual property, state aid, also in the energy sector. And she's also involved in arbitration proceedings, mainly between investors and member states based on the Energy Charter Treaty. She has often represented the European Commission in proceedings before arbitral tribunals or national jurisdictions in third countries. Prior to joining the European Commission, Petra worked in Brussels for leading international law firms. We also have here James Roger. He's a partner with Norton Rose Fulbright. James is an international arbitration lawyer based in London, and his experience extends across a broad range of industry sector, includes corporate, commercial, technology, M&A, licensing, joint venture disputes. He has a particular experience in the energy infrastructure and construction sectors, and significant recent experience in arbitration matters involving states and state-controlled entities. James has practiced law in New Zealand, Hong Kong, Japan, and the UK, and is advising clients basically throughout the world. He also accepts arbitrator appointments and is recommended by legal directories such as Chambers and Partners. Next we have Anna Stanic. Anna is a founder of IUNIE Law, is a boutique law firm focusing on energy, environmental arbitration, international and EU law. Prior to setting up IUNIE Law, she worked for 12 years in government and major legal firms. Anna is based in London since 1998 and specializes in providing tailored advice and legal representation services to states, international institutions, energy companies in the fields of energy, dispute resolution, EU and international law. She regularly acts as counsel in investment treaties and commercial arbitrations, including gas price reviews, and she's really reputed for her expertise in dealing with state-to-state matters. Anna is a solicitor advocate with rights of audience in the English and Australian courts, as well as the Court of Justice of the European Union, and she's also a member of the Permanent Court of Arbitration in The Hague. And then last but not least, we have Dr. Rimantas Daiotas. I hope I said it right. Rimantas is an international dispute expert with a broad range experience in international law matters. He's a partner with Motieka Law Firm, a leading law firm in Lithuania. Rimantas has extensive experience in the international arbitration disputes arising from bilateral and multilateral investment treaties, but also high-value commercial agreements. He sits as arbitrator or expert in international disputes and is also listed as recommended arbitrator at numerous arbitral institutions around the world. Rimantas represents clients before the Court of Justice of European Union and the European Court of Human Rights, and he is also recommended by international rankings such as GAR 100, Who's Who Arbitration, Legal 500, and the likes. So, welcome to all of you. Thank you for accepting the invitation to join this panel. And now that we are done with the introduction, I would say let's kick off the discussion on our first topic, EU energy policies. And since we have Petra here from the Commission, I would kindly ask you to start to briefly, set the scene on EU energy policies. with, you know, short-term objectives, long-term objectives. Thank you.
Okay, thank you very much, Ramona, and good morning, everyone. Thank you for a very nice introduction. We agreed to sort of do a more interactive panel, so I will not be speaking for 20 minutes, but I will present some of the measures and then leave my colleagues to comment on those. So perhaps let's do it by the different measures, if that's okay, so that you don't get bored with my voice too much. I think we've already had a very good introduction from Professor Cameron, and I'm very, very grateful for that. And so I will more focused on the measures that are currently sort of being discussed. Some of them have been adopted, some of them are still being discussed in the Council. So while all the proposals that the Commission put forward have now been published, the final form or the final set of rules that will eventually be approved by the Council and the Parliament are still very much in the making. So indeed, we can sort of see what is desirable and what is being discussed. Professor Cameron already mentioned the sort of, let's say, the biggest, the overarching package, which is this Fit for 52 package. Why do we say Fit for 52? Well, pardon, 55. We say that because the European Union made a very, let's say, ambitious goal to become climate neutral by 2050, and set also in the law, in a regulation that has been approved in July last year, the intermediate target of reducing net greenhouse gas emissions by at least 55% by already 2030, so in now less than 8 years. So that's why we have the Fit for 55 package. This is the 55% reduction. Now, this has been sort of enshrined in the law, so now the Union is legally obliged to sort of propose a set of legislative proposals that sort of accompany this target and that make this target happen, or that should make this target happen. And that's why we are speaking sort of in the press and also in sort of the EU language about the Fit for 55 package. So these are a number of measures, a number of legislative proposals. I will not go in detail through each of them because we would be here by tomorrow and you would not hear any of the other very interesting discussions. But basically, what is included in the package, so you have indeed proposals that bolster the investments in renewables energy, that are even more ambitious on energy efficiency than the current legislation. You also have measures in transport, which are novel in the sense that now we introduce certain provisions on alternative fuels infrastructure and the corresponding financing to that. So in all sectors, not just in the road transport sector for cars, but also for planes, for ships, basically accelerating the deployment of infrastructure for recharging and refueling vehicles and other means of transport with alternative fuels. And this is coupled also with some restrictions, with sort of the obligation, I think this has been now announced also in the press that this has been approved by European Parliament yesterday, to basically drastically reduce and even stop by 2035 the production of, or the manufacturing and the sort of placement on the market of vehicles that are propelled by fuels, by diesel and by petrol. And then you also have certain measures in the energy taxation, and all these measures that are, let's say, measures within the Union are also accompanied by measures that look a bit outside the Union, so that we don't get into the Union import of, let's say, products that are not environmental friendly, that or that sort of entail large carbon production, and that we also avoid that industries that are currently located in the EU relocate outside Europe to sort of avoid all these obligations. So this is the so-called carbon leakage. So you also have a mechanism. There are already some rules in place, but you have a new mechanism, which is the so-called carbon border adjustment mechanism, which sort of deals with these measures outside Europe and which imposes for some sectors the classical energy intensive sectors, so steel, aluminium, there are others. They are listed in the proposal. So that imposes on those sectors, on products imported into the EU, specific obligations on registration and on sort of paying a specific carbon tax unless they can prove that they have sort of abide to certain environmental friendly conditions that are set in the draft proposal. So I will stop there. I will give my floor to colleagues who wish to comment on this sort of Fit for 55 package, and then we can move on the more targeted measures to tackle the current crisis on energy prices and the war in Ukraine. Thank you.
Thank you very much, Petra, for this. Well, it sounds like Europe, or the EU at least, has very ambitious plans within a short period of time. So Anna, how would you comment on this Fit for 55 package? Do you think it's, you know, realistic? It is achievable within the set time frame?
Well, I'll slightly make another comment, and I think that's that the target shifts, and as we can see, the target shifts all the time, and it's slightly schizophrenic because we have on the one hand statements made on climate change targets and all these new measures, and they are quite challenging. I mean, just to put it into focus in terms of the energy sector, what it means, I mean, the fact is that the total energy use accounts approximately to 75% of all direct greenhouse gas emissions. So energy sector is crucial in how we achieve those targets. So, you know, the impact on the energy sector of all these measures is enormous. Why I say it's schizophrenic? Because at the same time as we have these new measures being proposed and we have the constantly increased new targets, now we have another energy efficiency target, which is much higher than even 2 years ago, and so on. We also have the European Commission in the Repower document just telling us that all of a sudden coal is going to be fine, and gas thermal power plants are also going to be fine. So we have these completely opposite statements being made, and I appreciate the argument that one is short-term and one is long-term, but short-term is no longer short. I mean, what is short-term if the target is 2030 for, you know, to achieve Fit for 55? So I think the basic situation is that the energy sector is in a total state of confusion. We still haven't got a real hydrogen regulatory framework to even talk about how we're going to build the structures that we're going to build. So the uncertainty is enormous. And when we come later on in discussions on the energy disputes, I mean, just what Petra was mentioning in terms of the carbon adjustment mechanism, there are already indications that numbers of countries outside the EU will challenge this in terms of breaches of WTO rules. So we actually have set up, in terms of energy disputes and what we're talking about today, a huge number of new types of disputes that are going to arise as a result of this, on the one hand, supposedly highly ambitious climate change targets, and on the other hand, a completely opposite statement in terms of how we're going to achieve energy, be energy free of Russian gas, which are completely opposite statements from the Commission. One other comment that I would say is that a lot of what we see now as Commission statements and proposals are quite different to the type of Commission proposal we have seen in the past. The Commission is far more political now, and the kind of statements that it makes, as we've already seen with the Repower document, the 8th of March document, is quite different to the one that Peter was talking about on the 18th of May. The whole argument of the reducing a dependency on Russian gas by 2/3 by the end of the year, it's disappeared now already from the 18th of May proposal. So I think we have to now look at Commission's proposals in a slightly different way to the way we've looked at them in the past. And I think there'll be a lot more adjustments to the Commission's proposals than we have seen before, because I think the Commission, you can argue that it's given the circumstances that we're in, is basically developing policy on the hoof and on its own, with little consultation by member states, and that consultation is happening only afterwards. So we are sort of almost seeing the thinking of the Commission being served to us, and I'm not even sure to what extent the actual DGs, including DG Competition or others, are consulted on many of these proposals as they're coming. So I think I would say that for the purposes of lawyers and that are working in this field, we need to look at, as Pete said, the sort of the slower trends as in some ways indicators of where we're going to go, rather than the continuing announcements by Ursula von der Leyen and others of policy. So I think we need to sort of step back and be affected less by Twitter and other things, I would say, in terms of as lawyers reacting to what's going to happen next. I'm hoping that actually we'll still have a steady approach to energy policy and not a redrafting of it entirely, as it currently seems to be indicated by the Commission.
Thank you very much, Anna. You are right, actually energy projects do take a long time to be made, and then policies themselves take a long time at national level to be drafted and implemented, and you actually touched on a very interesting point here in Romania as well, because you are saying, well, and we are jumping a bit ahead to the second part, that that now somehow the Commission is encouraging extending a bit the life of coal power plants rather than, you know, phasing it out completely. And then it says that, you know, actually maybe it's not such a great idea to use gas as a transition fuel anymore, and you can just skip it altogether and go to renewables. But in practice, we all know that life doesn't work like that, and you cannot just have a gas project stopped all of a sudden, or you can start, you know, exploiting gas from one day to the other, or extending the life of a coal power plant. You know, it requires huge investments, and then you need to take into account, but what do you do with the carbon price, and how do you handle all these aspects? So yes, challenging, definitely challenging times. Petra, you were mentioning briefly the so-called, well, as part of the EU policies and means to achieve the climate neutral status by 2050, you were mentioning also the EU taxonomy. And also the carbon border adjustment mechanism. Again, I'm not a litigation lawyer, but to me these two areas do seem like, again, giving rise to lots of disputes in the future, given, you know, reporting obligations on one side, then how would you implement this carbon price on imports of products, and you know, how this will impact the whole commodities market. Would any of you want to comment a bit on these two acts, or maybe just to give a bit of more details about them? Well, one is a proposal, one is an act already.
Yeah, so I actually haven't mentioned the EU taxonomy, so thank you for reminding that. I think I've already addressed the carbon border mechanism, so there I would leave space to more to comments. Just one quick caveat, which I forgot to mention. I always do it on my slides, but today we don't have slides, so I forgot. Just to let, I speak in my personal capacity and do not engage sort of the European Commission in anything that I say. So I just wanted to be on record also, because we are streamed. Thank you for the comment, Anna. Perhaps just a quick thing, and we will address this in the following. I mean, indeed, the Fit for 55 package is something that has been in the minds, that sort of has gone through all the stages that a European legislation goes, so through the public consultation, impact assessment. This is something that sort of has been prepared, you know, in the normal course of how union legislation is prepared. Of course, there are other acts or proposals or communications that have not, and this is due to the current economic social situation. We are sort of faced with unprecedented crisis. We are just out of the pandemics, hopefully, and now we get into sort of the energy crisis and the war with Ukraine. So indeed, there are needs to sort of react quickly. And that's why, indeed, there are some cases where things are sort of, where acts are adopted in a bit more urgent procedure. Now, just maybe lessons learned from the COVID pandemics. I mean, many measures that have been approved by the Commission, as for instance, state aid measures, which would have not normally been approved, you know, in a normal setup, have been scrutinized by the Court of Justice, and I think there is a sort of big success of those Commission measures, those sort of state aid decisions being upheld, and those that have been annulled because things, you know, were done really hastily, and there were, I mean, nobody's perfect, there were errors committed, as claimed by the General Court. Those, at least the General Court, you know, applying realpolitik, let's say, delayed the execution of the judgment for some time. So the measures could continue to be applied by the member states until the Commission sort of corrects the mistake. So this is just a side comment. Now, turning back to the question on sort of you know, these other two controversial proposals. So the EU taxonomy is a set of rules that somehow accompany this whole energy package that is being prepared, and it's mainly a tool to provide companies, to provide stakeholders with the appropriate definitions on which economic activities can be considered environmentally sustainable. So there is a big discussion what is sustainable, what is not, and the idea of the EU taxonomy behind is to sort of create a level playing field among member states and to all be working with the same definitions. Now, of course, things are not you know, as easy as they are. There are, I mean, the biggest discussion that was held in the sector was, I think, back in February, where the Commission adopted one of the sort of delegated acts which further implements the basic regulation on taxonomy, and by which the Commission included in the definition of environmentally sustainable activities, specific nuclear and gas energy activities. So indeed, there was a big shout of sort of you know, environmental friendly, of environmental NGOs and stakeholders that this should not be the case. It's also true, and this is all in the public domain, that the Commission concluded those criteria for specific gas and nuclear activities on the basis of some studies which are published. So that's why sort of, you know, this is not just a political decision, this is a funded decision that was made with some background information in mind, also taking into account that we have also some Court of Justice judgments which sort of confirm that member states can invest in nuclear energy, and which do not condemn that nuclear energy as a sort of fossil fuel energy, which it is not. So so far on that, I perhaps leave again space for comments so that we can move on. Thank you.
Thank you very much, Petra. I would actually propose to move to the second part of our panel, where we are touching on the current energy crisis, and starting first with what we've been experienced last year. So even before the conflict between Russia and Ukraine has, you know, intensified everything, just to put it mildly. So we all, I guess, you know, we all read it in the newspaper, but it's not just reading in the newspaper, it's also, we feel it in our bill. Energy crises across Europe have spiked at, you know, so sort of unprecedented levels. And this is due to a number of factors. You know, it's not just the energy transition, it's some shortages in supply due to some extreme weather events. There is also the energy demand rebound after the pandemics and so on. So all that led to a huge spike in energy prices. It was mentioned earlier well, actually, Professor Cameron mentioned already that EU prepared a toolbox of measures that could be implemented by state, or sort of a guideline for states to address the impact of the increase in prices. So if Petra or Anna could touch a bit on these measures at EU level, and then actually I would be more interested in even to comment a bit how have the various jurisdictions approached the price increases, what were the measures taken at the local level, and here I would kindly ask James and Rimantas as well to comment on it. Thank you.
I'll be very brief so that you hear other voices too. So on the energy crisis, so again, as I said, these are the two big exceptional circumstances that were foreseen. So the Commission and the Union tries to react quickly to sort of provide the tools to the member states to put in place measures that are effective and that tackle directly these issues and that touch directly on the citizens and companies. On the price measures, so Professor Cameron also mentioned in October last year, the Commission adopted the so-called energy price toolbox, which was further amended also this March. And there the idea was to present certain measures that would help member states to indeed mitigate the impact of the high prices, with a particular focus on vulnerable consumers. And there it was proposed to authorize, for instance, temporary deferrals of bill payments, to grant subsidies to industries, or even to sort of some exemptions from the energy bills, which would normally constitute incompatible state aid. But in this sort of framework, in this exceptional framework, this is now approved. There is also even a exceptional state aid framework to tackle this crisis, the so-called state aid temporary crisis framework, which was adopted also in March this year, which allows against temporarily these measures. Then on the crisis in Ukraine, again, very briefly, because Professor Cameron also already mentioned this, so sort of this is now addressed by the so-called Repower EU plan. In the same way as for the energy prices, there are certain measures that are short-term, which are proposed in order to sort of immediately react to the situation, and then there's other measures that are midterm, that are sort of let's say more elaborate. Perhaps starting with the midterm, mid/long-term measures. So just an example. So indeed, more investment into renewables, more investment into hydrogens, accelerating let's say the bolstering of the hydrogen products and of alternative sources of energy that would make Europe completely independent from Russian gas. And on the short-term measures, so this creation of the common purchases platform of gas, LNG, hydrogen, so this creation of the EU energy platform for all member states, but also for some member states, for some other states around, including Ukraine, Moldova, and Balkans. And, you know, very important, winter is coming, not just in Winterfell, but unfortunately also in Europe. So in less than 5 months, there will be winter, and that's why there is now an obligation, I think a strong incentive to fill gas storage, or a commitment to fill gas storages in Europe to 80%. By 1st of November, which will then be increased, I think, up to 90% as of next year. So these are the sort of the key measures that would address the upcoming shortage of gas, the upcoming winter, and also the high energy prices. So now I leave the floor to the colleagues. Thank you.
Thank you very much, Petra. James or Anna, who wants to take it?
You want to do the joint purchase, or what do you do? Okay. All right. Maybe just to talk about the short-term measure that is meant to address the, try to avoid a rationing of gas by the end of the year, which is being proposed by the Commission. And I think it's obviously a regulation that it's just a question of time when it's going to be adopted, but in the next weeks, which is the storage regulation. And Petra's already mentioned the key elements of it, which is basically ensuring that we have 80% of the storage filled within the EU by October, sorry, 1st of November of this year. The key debates that are still raging, but I think will be resolved, are to do with who pays for the storage, in particular with respect to countries that have no storage and other countries that have more storage than they themselves need, and so somebody has to actually pay for that. I assume that will be resolved. It does help that the prices now of gas are no longer negative in terms of a negative inversion, where the prices of November gas was cheaper than the gas today, so nobody had any incentive in storing gas. That has now changed, so the actual need to subsidize or to provide for measures to ensure that storage does happen is less of an onerous burden on companies and states. I think the key thing that I think, as I foreshadowed before, that has changed, I think, in the position of the Commission and the Repower document from 8th of March and the 18th of May is that, as I said, the 2/3 objective has been dropped, and mainly because it was completely unrealistic. An idea, even if we were to achieve it by the end of this year, which is unachievable, we certainly can't achieve it next year or the year after. So the whole idea of this independence from Russian gas, the sooner we realize that it's certainly not an objective achievable before 2026, even if it were to be achievable then, because obviously the question is one of a technical nature, whether it's physically achievable, and the second is what's the cost of it. And I think that has sort of hopefully changed the thinking, or at least brought some realism into the thinking of the Commission. I think that the taxonomy point that was raised and that Petra mentioned, and the Commission delegated regulation that now clarifies that nuclear energy and gas in certain instances come within the sustainability definition, is helpful in the sense, certainly in addressing, for example, the objective of being free of Russian gas in the long term. But the key problem there is that it's clearly going to be challenged. It's challenged by a significant number of states, not least Germany and Austria, and there are others that are quite unhappy with it. So we expect it to go to court. And even if it was ultimately resolved that it is sustainable, it will take years for that to be clarified, and in the meantime, we will have uncertainty. On the joint purchasing point, because I think it's been raised a number of times, the interesting thing again is that the wording has changed. So as Peter mentioned, now it's talking about it being a voluntary thing. Again, if we are freeing ourselves from Russian gas, then presumably this joint purchasing arrangement is directed at buying the gas from America or buying the gas from Qatar and so on. It's quite difficult to understand this proposition coming from the Commission when the market for gas is clearly quite global now. And one of the main arguments the Commission had just last year was that the market for, or the pricing of LNG is completely global. So how we are going to influence a market that is global in terms of price by joining forces, and who would be joining forces. Initially, the argument was that member states would be somehow buying it. In fact, it would probably be the Commission and buying it on behalf, like it did for the vaccines. But I don't think that is a realistic proposition. It's a slightly more complicated arrangement, and in any event, even the buying of the vaccines wasn't exactly the greatest of successes. I think we paid, as the European Union, more for the third batch of vaccines than the individuals, member states, did when they bought them themselves. So I think there's lots of questions on this. The main concern, of course, is that the state aid, I mean, one of the solutions that when you were asking about the price cap, what has been happening in the numbers of member states, and it has been permitted by the Commission, is to allow price caps. This is now causing a huge impact in the market, and it's obviously unwinding the whole logic of the liberalized market. And obviously it's not just enough to address household issues. The industry is asking for similar things. The solution of allowing state aid and allowing member states to subsidize effectively industries is which countries can afford this? Maybe Germany can afford it and France can afford it, but I think even with the COVID measures and the state aid used to help industry and individuals, we've seen a huge difference between the kind of measures and support that large and wealthy member states have been able to do vis-a-vis others, whether it's Romania, Slovenia, Croatia, and the others. And this this is actually now affecting real things like actual level playing field in terms of competition of companies. So how is a Romanian company with a limited amount of state aid that it can get going to compete against a German company that has just been flooded with money because they can afford the state aid? And to what extent are these exceptional circumstances effectively going to undermine what I would say is the fundamental basis on which everybody entered into the European Union, and that was that it guarantees a level playing field and competition. And now state aid is effectively enabling large member states and wealthy member states to change those rules. And I think just as an indication of the impact, and this is pre-war in Ukraine, the number of companies from Germany knocking on the doors of Slovenian companies and wanting to buy them because they're flooded with cash during the epidemic has been unprecedented compared to before that. So these are now raising fundamental questions, certainly in countries in Central and Eastern Europe, about the European Union. And so this really has to be considered within a much broader context. Bringing it back to the energy companies, it's making it very difficult for energy companies in Central and Eastern Europe to compete on a level playing field within the EU. Let alone talk about a joint purchasing agreement vis-a-vis America. Thank you.
Thank you very much, Anna. Very insightful and so true, actually, your comments. James, would you like to comment a bit on measures taken by the UK government in this context?
Sure, thank you. I admit I'm not particularly well qualified as a New Zealander living in the UK to speak to European policy, but I might start by mentioning a ancient Chinese proverb that I'm sure many of you have heard, and that's, may you live in exciting times. We know it as a proverb, but it was in fact a curse, because in ancient times people couldn't deal with change and disruption, and so wanted to avoid it as much as they could. But now I think we need to see, and we do see, change and disruption as an opportunity. And while there's not a consensus even in this room, about what the right policy is, at least we're able to, governments are now able to collude together and to make policy and to make change or deal with change. And ultimately that's an opportunity. The pressure we're under now is going to accelerate efficiency in production and regulatory improvements, and I think that's a good thing. If you look back to oil price shocks in the 70s and the 80s, the response of governments there was to introduce policies to stabilise oil supplies, find more oil, invest in research and development. And in the 2000s, for example, what led to relief was a flood of oil and gas from the shale revolution in the US, which is all about innovation and exploratory techniques. Now, of course, we're moving away from oil and gas, but it's the same principles that the disruption we're facing now will ultimately, I hope, drive innovation. In the UK, we have had a new energy security strategy just released in April. For those of you who follow politics in the UK, it's been a very distracting period for the government. Boris Johnson, the Prime Minister, is under a lot of political pressure for all the obvious reasons. The war in the Ukraine, of course, rising fuel costs, inflation, cost of living crisis as it's described in the media. But the biggest discretion is his part in a birthday party that was held in his residence during the COVID break in breach of his own regulations. And so just this week there was a vote of no confidence to his leadership, to the Conservative Party, which he survived, although some would say not as well as he should have. So he is under a lot of pressure, and the government is under a lot of pressure. And so a big focus for them has been energy policy. Some would say to distract from the rest of the mess. But they've issued a 10-point plan, and in many ways it's the same approach as the EU have adopted. 3 key areas: energy savings, being more efficient in our use of energy, diversification of supply, particularly being less reliant on foreign resources, and lastly, accelerating renewables and clean energy, wind and solar obviously, but also hydrogen and nuclear. Most headlines, and this probably goes back to the trouble that Johnson is facing, are focused on the package of support that has been given to families in order to meet rising fuel costs and home energy bills. There's 9.1 billion of packages announced recently, and that has probably grabbed the most headlines, and in turn that is being funded by a windfall tax on oil and gas companies, which has also garnered a lot of headlines. So the rate of tax has increased to 60% for oil and gas companies. It's not yet been extended to the energy sector, but there's suggestions that it may be in due course. The obvious complaint to that is that will reduce long-term investment in the industry, reduce the attractiveness of the UK for oil and gas investment when the government actually wants to ramp up local supplies and boost the North Sea. But in actual fact, looking a bit deeper, the levy can be offset by money invested in the sector in the UK. So while the likes of BP and Shell have complained that they will now need to review their ongoing investment in the UK, at least one Shell North Sea gas project appears to have been accelerated following recent government approval. This is a very big project which in turn may meet 6.5% of the UK's gas needs. So I think the government is trying to walk a very fine line between getting tax revenue to meet its increasing obligations, but also, and in doing so, appeasing the population, the man on the street, but at the same time trying to encourage continued investment in the industry. So tellingly, the front cover of the report actually has a photo of the Hinkley Point C nuclear project. So that was obviously a very intentional choice of image on the front cover, and reflects the aim that 25% of power consumed in the UK by 2050 may come from nuclear. This is a very ambitious target from the government. Been spiraling costs on UK nuclear projects over the last few years. Difficulties about ownership, concerns about Chinese ownership of some of those projects, and difficulties in having them green lighted, given the level at which the electricity supply has been priced into the future. But the government very much sees nuclear as an important part of the puzzle. There's also a focus on developing technologies, hydrogen, carbon capture, usage and storage. There's a number of projects on that front, particularly in the north of England, which is a focus for the government. In the UK, well, in England itself, there's regularly complaints about the disparity between the south and the north of the country, and so that has always been a focus for this government, to try and bring industry and investment to the north. Our firm is in fact involved in one of the largest projects in this space, a hydrogen production and what's called CCUS, carbon capture, usage and storage hub on the Humber side in North England, traditionally a area of heavy industry, sort of coal-fired power stations and industrial complex around the port terminals and whatnot there. So I have a quote here, which from Boris Johnson himself. I'm not usually someone who talks about him a lot, so I find it a little bit weird I've used his name so much in the last 5 minutes, but as he explained in the foreword to the strategy, if we're going to get prices down and keep them there for the long term, we need a flow of energy that is affordable, clean, and above all secure. We need a power supply that's made in Britain, for Britain, and that's what this plan is all about. Self-sufficiency and security. And these are, of course, themes that resonate well with the current Conservative government, which was elected on its mandate to get Brexit done and get out of Europe. And whether or not you agree that leaving Europe made much sense, I don't happen to believe that it did. But whether or not you agree with that, it does seem an obvious approach to aim to become world-leading in new technologies and renewables while mitigating dependency on foreign oil and gas. So that's the UK. As I mentioned, I'm from New Zealand, so I'm just going to offer one observation from New Zealand, where one of the greatest concerns there is methane gas and efforts to curb the burping of cows, which is one of the major contributors to the greenhouse problem from New Zealand. So different problems in different countries.
Thank you very much, James. Actually, it was very informative. So even if you are from New Zealand, you still know a lot of things about the UK market. Next time we'll ask about New Zealand, but now we are conscious about time.
Other than the cows, I don't know much about New Zealand, not having lived there for the last 20 years. But
Rimantas, if you could briefly touch on what is the situation in the Baltics, that would be great, and then we'll move to the third part of our session. Thank you.
Yeah, thank you. So I think what we are seeing here is sort of, I have a deja vu moment, and I come from Lithuania, and we had this sort of divorce with the Russian oil and electricity and gas 10 years ago. And before that, Lithuanian market was completely dependent, 100% from Russian gas, also oil and electricity. And this sort of divorce, which I worked on personally as well, it took for Lithuania like 10 years to end this divorce. So, and it's only on the national level, on national scale. And I think what we will have, of course, we will talk about disputes, and this divorce will be on a much sort of larger scale in the EU. And Lithuania, for example, when they had this divorce, they very quickly came up with the plan to build their own LNG terminal, which now is very useful, and this terminal serves also the other Baltic states. And as we see, the LNG is the main topic now because it's the most available readily for the European market. And of course, the countries which will sort of have the biggest advantage of LNG are the countries which has a coastal line, which can build LNG quickly. The landlocked countries will be much more dependent on imports because they still will need to use the in majority Russian-owned pipelines to get their LNG, which will have another problem there. The European approach, as we talked about, the repower, I think in the short term, it is very ambitious. It will include building fast and efficient renewable energy stations, which again will include many construction disputes, and of course lots of it will have a pressure both on the construction side and both on the governments, and this will also lead to other disputes as well. The oil sector, again, the oil sector has its own bottlenecks, which mainly are refineries. We have problem with refineries because most of them, especially in Central Europe, Eastern Europe, are not capable of sort of manufacturing Western oil. They are basically dependent on the sort of dependent on the Russian oil. It will be a bottleneck to do that. They will need to sort of diversify on that point. The LNG terminals, again, as I mentioned, will be the fastest point to diversify, and of course we'll also have a problem with the interconnections. Most of the interconnections in the Eastern Europe are Russian owned as well. The nuclear power, again, there's a lot of nuclear stations built in Europe which were built by Russian companies and are dependent on the Russian imports of nuclear energy. And yeah, I think we'll have this a long, very heated and difficult divorce with the Russian energy, but difficult times require difficult measures. So that's what we will face, in the future.
Thank you very much for that. So now that we have kind of set the scene for where we stand in terms of the energy market, I think we can move to our last part of the session, which probably is the most interesting for all of you, given that this is an arbitration event. And this is, energy disputes or disputes in the energy sector that you see coming up in the next period. And here, because I'm conscious of the time, I think we have about 10 minutes left. If each of you could say a few words of what you see more relevant now, what are the types of disputes that you see more often. I myself, I'm not a litigator, but I've seen that, NGOs are much more active lately in this context. They sue companies, they sue governments, they are even successful in certain circumstances. So if you could, each of you, tell me a few words, that would be much appreciated. Thank you.
Can I start with a counterpoint to that? You're absolutely right that we will see the rise of activist-type disputes and state-on-state disputes arising out of the current circumstances and increasing climate change regulation, what have you. But whenever I'm asked to discuss this topic, I always refer back to a partners conference we had during the course of COVID. So it wasn't the most exciting event because it was all held virtually. But one of the presentations was on precisely this topic. And leading the presentation were two of our US partners who gave a presentation each on a dispute, on one dispute each that they'd been involved on, and as examples of the new types of disputes that they were facing as a result of climate change and the energy transition and what have you. And one of those disputes was the restructuring of a major power company that had got into trouble following significant storms in Texas, which had destroyed a lot of infrastructure and consequently led to the insolvency of this company. And the other one was what I thought was a rather run-of-the-mill financing dispute that happened to be about a wind farm. These are not new disputes. They're the same type of dispute we as a firm deal with day to day as energy infrastructure dispute lawyers. So my message, if there is one, is that yes, there will be new types of disputes, as I've touched on, but what we're in fact seeing is an ongoing diet of the common energy-related contractual disputes, but with a change in subject matter. So we still have upstream and midstream infrastructure disputes, we have joint venture and operating disputes, we have project financing disputes, post-disposal and M&A disputes. Sure, we're arguing less about oil and gas, and more over wind projects or new technologies, and the relationships that spring up around those new technologies, but ultimately, often the type of dispute, the core dispute, is the same.
Thank you, James. Anna?
Maybe because, I mean, the remit of the different types of disputes, energy disputes, it's sort of quite enormous. So maybe I'll just concentrate on one aspect, and that is the expected growth of climate-related disputes, and specifically with respect to investment treaty disputes. So I think we've seen already, I would say, sort of three types of these disputes. One is one where the investor sues a state for the failure to take preventive measures against climate change that they then say has harmed the investment. So that we've already seen. It's obviously the causality has been the hardest thing to establish, but obviously that trend will probably likely to continue. The second type of investment disputes we've seen is one that Peter already mentioned, and there's all the disputes with respect to the renewable incentives that were provided, and Romania has been party to some of these disputes, so you know all about them. So that's really sort of the reversing of the course of regulatory frameworks. Ironically, for renewables, so it sort of puts the whole argument on the other foot in terms of the arguments that have been put forward against arbitration to resolve these disputes. And then finally, the types of disputes that we've actually seen in the last 2 years is introducing measures specifically to combat climate change, whether it's phasing out of coal, or in going forward potentially even gas or nuclear or whatever it is that they decide further down the track to change their minds on, then that actually triggers large disputes. And you've seen dispute, one of the main ones in RWE and Shell in respect to phase out of coal, but there'll be many others. And all the stuff that we talked about with Petra at the beginning of the in the first part of this discussion is really an indication of the regulatory complexity and the radical changes of the laws will trigger more disputes of the types of these three types that I've just mentioned. So I'll stop there.
Thank you very much, Anna. Rimantas, did you want to say a few words?
Yeah, I think we can sort of summarize of the disputes that we see coming. So the ones which concern the supply chain, we will see a lot of disputes on the failures of performance, force majeure clauses, hardship clauses. It depends on the contract. A round of pricing disputes, price review disputes, again in the long-term contracts of oil and gas. The others will be, of course, issues with the payments in ruble. We will have those as well, and we will see how the contracts will be interpreted and how they will be applied on that side. Then we will see, of course, the Repower initiative, who will embark on new construction projects, especially in the renewables. And that will be new pipelines, new LNG infrastructure that will be under compressed pressure to deliver these projects fast and free of defects. So that will be another portion of disputes. Then, of course, the withdrawal of investments in Russia and joint ventures, as mentioned. And of course, the sanctions issues will generate a lot of disputes. We already see them in the Baltic region, and we will see much more, I think, on the EU market as well. So I think these are the main points to address.
Thank you very much, Rimantas. And thanks for mentioning the whole drama with the rubles payments. We actually wanted to touch on that a bit more, and Anna is actually an expert on this topic, I would say. But due to time limitation, I think we'll leave it for next time. But on this, I actually read that a Finnish gas supplier, is planning to start arbitration against Gazprom for stopping supplies and the whole issue. So let's see, yeah. Petra, would you mind saying a few words of, what you see from the Commission perspective in terms of disputes on the horizon?
No, so what I see is many disputes coming, so I can't say which are, because there are really all sorts. Perhaps I may say a few words on the disputes that hopefully will phase out, or I wish they would phase out, which is indeed these investment state arbitration issues for cases that are, let's say, as we call them, intra-EU, so where you have an investment from a member state suing another member state based on extra-EU treaties in particular. And that's why we are also in the energy sector on the Energy Charter Treaty, which is a treaty, as many of you know, which is an international treaty to which actually the European Union as such is party, and also many of the contracting member states, but which was signed in the 90s, I think, entered into force in 1998. Basically with the objective to allow secure investments by European companies in third countries. So today in countries that are outside the EU, but back in the 90s also, investments by companies from the Netherlands, from Germany into the new acceding countries, Czech Republic, Romania, etc. So this was a bit the objective. However, with the enlargements, and about, I think, 10 years ago, investors decided to use that treaty, which has an arbitration clause there. There's the famous Article 26, which allows for the investors to sue contracting parties to also attack certain measures within the EU. So in particular, measures in Spain, in Czech Republic, in Italy. I think you will have tomorrow a colleague from the Spanish government, so he's really the big expert on these cases. And when the Commission became aware of these arbitration cases, it started acting as an amicus curiae, so we started to send let's say, requests for intervene as non-disputing parties in these arbitration cases, which is why I sort of became and also involved without really being an arbitration expert, basically trying to explain to the arbitral tribunal that indeed in intra-EU sphere, the arbitral tribunal should not have jurisdiction, because once you are within the union, it's the European Union that takes precedence on the basis of, you know, first year law degree case law, Costa Enel, classic Cimental, etc., where you are sort of where the EU law takes precedence, and also one cannot take out of the jurisdiction of the European Court certain disputes that should have normally been decided by EU court. So this was the main argument behind the Commission's thinking and the sort of main focus of our amicus briefs, which was also sort of indeed one of the arguments of the member states. Indeed, this argument has not found very much success with the arbitration tribunals, who continue to accept jurisdictions on these cases. However, we have found sympathy in the European Court of Justice that basically seconded these views in a series of judgments, starting with ACMEA in 2018, on the basis of which, however, only concerned a bilateral investment treaty, which is a similar which is a similar type of agreement to the investment, to the Energy Charter Treaty, but only a bilateral. But then also recently in relation specifically to the Energy Charter Treaty in the judgment of 2019, Komstroj Moldavie, where the court indeed confirmed that member states cannot take away of the jurisdiction of the European courts this type of investor-state issues. And then also more recently in the famous Mikula case, so there was a judgment on appeal which was issued in January this year, where indeed it's quite interesting where I found there, because there the court makes a distinction from the classical commercial arbitration proceedings, where it says, well, there indeed the party consent to in a specific agreement to such a dispute, and in an event that dispute is then reviewable in EU courts. However, here in the framework of the Energy Charter Treaty, in the framework of the bilateral investment treaties, what happened is that member states, not the parties to the dispute, but member states, agreed to exclude from the jurisdiction of their own courts disputes which may concern interpretation or application of union law in favor of arbitration proceedings, and this is against the treaty. Therefore, it confirmed, in particular in relation to the bilateral investment treaty that was at that time signed between Romania and, I believe, Sweden, that the consent given to that effect by Romania when it signed the BIT lacked any force as of the moment Romania acceded the European Union. And then you also have a third judgment. I'm happy to put that on slides and circulate it if people are interested. Just let me know. On the PL Holdings, which again sort of in whole this area confirms that member states must take all the necessary measure in order to prevent the enforcement of these arbitral awards. So that's why also many vice investors go outside the EU, go to third countries, go to Australia, go to the UK now, go to the US in order to have their award enforced. However, there has not yet been a ruling confirming the enforcement of an intra-EU award in those jurisdictions. And last but not least, and I finish with that, also in this whole saga, you have an upcoming opinion of the Court of Justice now in a week from now, on the 16th of June, which again should address the issue that has already been put before the court in Komstroj. Namely, there you have a question which was asked by Belgium to the court to sort of provide a formal opinion on whether the Energy Charter Treaty is compatible with the treaty. So there There, the opinion will be issued next week. This is now on the judicial calendar of the European Court of Justice. And, well, given that there was no hearing, no Advocate General, a question remains whether the Court of Justice will deviate from its Grand Chamber ruling in Comstroy or whether it will confirm it. So that we will know. We will know next week. So with all these judgments in mind, again, well, I at least personally hope that it's a matter of time that indeed this will be taken into account also by the arbitration community and by the tribunals who eventually will take away the intra-EU disputes. But still, this is a fiction and not a reality. So here, it's the other way around. Thank you very much.
Thank you. Thank you very much, Petra. So I don't think we have any more time left, but I would say if there are any questions from the audience, now is the time. No? Then I would like to thank you very much for these discussions. It was really a very insightful session, for me at least. You gave us a lot of food for thought. It looks like all of you will be very busy in the next period. And I would also like to thank the audience for bearing with us just before lunch. And I wish you an excellent conference ahead and bon appetit.
Well, good afternoon. Welcome back. We'll continue the work of our conference with the second panel, which is focused on infrastructure and energy project, and is aimed at demonstrating why the commercial arbitration should be regarded as a preferred dispute resolution mechanism. As a first step, of course, I'm going to speak the jokes regarding lunch, and I go directly to the presentation of the panelists. And in order to give an appearance of good order, I'll start by the first person sitting next to me, who is Luminița Popa. For all the Romanians in the room, she doesn't need a special introduction, maybe also for other people coming from or watching us from abroad. She's partner with the well-established Romanian law firm, Suciu Popa. She focuses her practice, I think, in arbitration. You can meet her as working as counsel or arbitrator in cases in Romania and in Europe. She has, I have personally known her for almost 20 years, I think. I hope that this disclosure is not something that is going to, you know, she looks very much younger than me. Second speaker is Michael Polkinghorn. He's
who looks very much younger than you as well.
Well, I mentioned that a little bit earlier to Michael. I noticed that prominently in his presentation on the website of White & Case, he's a partner in the Paris office, by the way. It is said that he has a great sense of humor, and that's very good, because it will keep us very, you know, very careful about what he has to say. He's qualified in France and Australia. His list of cases and publications, I will not go through it. Our website has the possibility to view the biographies of all the speakers. You can do it by yourselves. It will take you a lot of time, I assure you, just to go through his list of cases and publications. Very impressive. The next speaker is Louise Woods. She's a partner with Vinson & Elkins. She's based in London. Again, impressive list of cases and publications. She must be one of those people for which there is more than 24 hours in a day, because I can not really explain how it was possible, humanly possible for her to be involved in so many matters. We also have online present Yaroslav Petrov. Our special thoughts go to him. He's in Ukraine. He's a partner in Astor's law firm in Kiev, which I had the privilege to visit in 2019, before the pandemic, and obviously before the war, which is, we are being told by some people that it's not a war, but it is a war, and we are very grateful to have the opportunity to have him with us. He will have a presentation which will be made at the end of our, near the end of the panel, to be more precise, which will be more focused on the situation which is unfolding in Ukraine. Before getting to that, we will start by trying to have a conversation about topics which we found that could be interesting for you to hear about. And in that context, it would be maybe appropriate to speak about the existence or non-existence of an appetite for the energy companies to agree on arbitration. It's a good place to start, and maybe look at various other forms of which we can discuss in the more general notion of ADR, alternative dispute resolution, things like mediation, expert determination, and of course we should not forget about the alternative of going to the national courts. So Michael, could you please help us start?
Thanks very much. Good afternoon, everybody. So the first question is really about the appetite of energy companies to resort to arbitration for resolution of their disputes. I think there is a positive and a negative answer to that question. The positive one is that arbitration has flexibility, it has confidentiality most of the time, that there is an ease of enforcement of an arbitral award, and you can rely on a reasonably neutral tribunal. That's the positive. The negative, I would suggest to you, is that frequently it's the best of a bad lot. You know, we can't sit here pretending that arbitration is perfect. It's not. We have our clients who find that it can be long, it can be expensive. They sometimes are a bit concerned about how a decision was reached. But the fact of the matter is, and again, I suggest that it's really the best solution out there. And I find that our clients, and I am an energy arbitration guy, they go to arbitration because that's really what you do. And it's really seen in that way. There was a survey, the Whiten Case Queen Mary survey, which is now about 4 years old, where this question was put out to the industry, and the results was 85% of the respondent group thought that international arbitration was likely to increase. Now, this was even before COVID, before the war. And so I think there is an expectation that arbitration is a growth area in terms of dispute resolution. The ICC says something very similar. If you look at their statistics, the ICC says that engineering and energy, so they are both, constitute 38 or 40% of all cases before the ICC. I suggest to you that's an enormous number. So it suggests, A, that within the industry, there are a lot of people looking to arbitration. But on top of that, within that industry, amongst that class, a lot of them are actually not simply having a clause, but going to arbitration. So I think that's a phenomenon that can't really be denied. So that's I'm going to keep this short. That's a little bit of reflection. But there are alternatives out there, and I'd like just to address a few of these, because I do have clients who do look. It's part of their job every once in a while to take stock and see if perhaps they should not just assume arbitration in every case. So do we see litigation? I've seen large energy companies think litigation could work in certain cases. They think, for example, publicity value might be a good thing. The fact that a litigation is before a national court and that you can share that, that's one reason that some people might like and other people hate. But nevertheless, often in domestic cases, it is thought perhaps domestic litigation can be an appropriate alternative, in some countries cheaper, not always, I've been learning from our colleagues. But I think that that's one area where you might see some. An area where I'm not sure energy companies are particularly thrilled to see litigation is climate change. If you look at the cases that are out there, and I was talking to a general counsel of a super major who said that at the moment they're facing roughly 180 litigations around the world on climate change. And of course, that's an area where it is the activists, the NGOs, from time to time local authorities see the publicity value of climate change also as something important in order to get their message across. And as I say, the energy companies may not so agree. Mediation, we keep trying mediation, we keep looking back to past attempts, and I would suggest to you the reason we look to mediation is because people are a little concerned about arbitration. They would like to avoid it. So it's in a way, it's dispute avoidance rather than resolution, but you obviously hope it leads to the right result. There have been moves there. There's the Singapore International Mediation Center. There's a United Nations Convention on Settlement Agreements. We all know how settlement works or doesn't work. You need buy-in from both sides. You need people to be ready to adhere to any mediation result, and that may or may not work. I would suggest it is something to consider, as we do, in long-term arrangements where parties are together for what might be 5, 10, 15 years. There is a huge incentive, I would suggest, to go to mediation to try and maintain relations between the parties. Expert determination. There are very technical disputes that would call for expert determination. The only reflection I would have there is that the problem that I've seen with these is that the clauses are badly drafted. It's as simple as that. It's not perfectly clear what exactly the expert has to determine and whether the expert can look outside the technical parameters to legal or something else. It can become a real hotbed of disputes. Another issue with these clauses is what happens once an expert determination has been made. Is that the end of the story? Are the parties bound, or can an unhappy party go to arbitration to say the expert got it wrong? Often, the contracts say little or nothing about that. So I'd say that expert determination, great idea, but be super careful. I'm mindful that time marches on. Just a quick word on dispute adjudication boards. People familiar with the construction industry are doubtless aware of these boards. The FIDIC draft contracts place great emphasis on the idea of having a panel who watch over projects and disputes as they bubble along, not waiting until it's ending in tears, but trying to resolve these beforehand. And the statistics suggest that these DABs or DRBs are in fact very effective at filtering out a lot of these disputes. And I'd suggest sort of an intellectual conceit of mine in some of these long-term agreements. I do a lot of gas pricing disputes, for example. Maybe a DAB could help there as well. I'll leave it there.
Just a few words. I definitely do agree with Michael that the arbitration is and is continuing to be the preferred method for resolving disputes. And I would say that in Romania, and not only, and especially in the context of the energy crisis, which occurred even before the war in Ukraine. We do remember that during the past 6 months, there were states regulating, re-regulating, modifying regulations and affecting the major companies and generally all the companies in the energy sector, electricity, gas, so on and so forth. So in the context where you have a private sector and energy is predominantly private in Europe, at least, and you have states regulating, it is all the more and continue to be extremely important to have arbitration as the available tool for resolving disputes, for all the obvious reasons and for all the clear arguments already brought. However, there are a number of cases and of situations when arbitration is not available. Regulatory compliance or corporate governance or consumer protection, for example. There are only 3 examples of situations when arbitration is not open. And if we look to the case law and to even to what we read in the newspapers, we see that things are not necessarily, I would say, going well, not because courts are not solving those disputes in a independent way, but because of the complications arising predominantly out of the lack of experience, of expertise in this specific area. Thank you.
It's a good thing that we don't have judges in the room, because they will jump and say, well, not very experienced. Louise, please, if you have something to add.
Yeah, I was just going to pick up on the point on expert determination. I sort of share your skepticism about how well that works in practice, usually, as you quite rightly point out, because the clause has been ill thought out. I would also say with DABs, in my experience, very often you end up in arbitration anyway, and so it just becomes a multi-tiered dispute resolution process that actually elongates the procedure overall. So I'd be interested to hear if anyone else on the panel or indeed in the audience has a different experience of DABs. And the other point I'd say about arbitration, and this is perhaps a downside, is it's not really ideal when you need an urgent solution to a situation. And so in those cases, you often find that going to a national court is a much better solution, for example, if you need urgent injunctive relief. And so again, I think there are certain instances where even with an arbitration agreement, you'll find yourself going to local courts because the remedies there on an urgent basis are just much more appropriate and more readily enforceable.
Just a follow-up question, if I may, regarding the DABs. The Romanian experience regarding the DABs has been somehow sour. from the perspective of the authorities, and there is a pushback from their part against the DABs. They now prefer to go directly to arbitration. In your experience in other countries, how is it regarded?
I mean, I'm not a construction lawyer, so I don't have a vast amount of experience with DABs, but I will say that from what I have seen personally, pretty much every single DAB award has resulted in a subsequent arbitration. So I would say my experience has not been great.
Yeah, mine's been more mixed. And I was careful to say that I think it works for filtering out disputes, not resolving all disputes. What I find a DAB good at, and part of this is born of my Asian experience. I'm out in Asia a good deal. And I'm looking, I can go back into history and the Hong Kong airport and some of these other projects. But what I found them useful in doing is just getting rid of a lot of the noise, the white noise that sort of centers around. If there's a profound problem, a DAB's not going to fix it. It's expressly set out in the contract. If someone's not happy, they have within a certain deadline to take the matter to arbitration. So absolutely agree that it's not in any way a guarantee of success. But I still think there's utility. I just think it has to be used wisely, and I'm not sure that's always the case.
But the way it was often perceived in a country like Romania, it was, well, it's written in the contract, it's the FIDIC standard form, they must have thought something about it when they wrote it, and we're using it because of that. But I'm not sure if this translates into a substantial, understanding of what should be the DAB about.
I do think horses for courses. I do think that your point is a good one. You don't just put it in for every construction project. But I do see that some of these are potentially quite complex. We've just handled a couple in the nuclear industry where the DABs were actually pretty helpful. But as I say, it's a mixed bag.
Coming back to energy, Yaroslav, we don't wish to, if you have something to add, just raise your hand and we'll give you the floor. If not, I will take silence as an expression of consent and I will move on. Coming back to energy, we've heard a lot about climate change and we'll be hearing a lot of it in the future. There is obviously an effort to make this transition to a new form of energy successfully. We'll see how it happens. How is it going to be translated in the occurrence and the unfolding of disputes? Luminica, can please help us?
Sure. Thank you. Well, climate change is producing, let's say, two major consequences. We're speaking on one hand about energy transition, which is a consequence of the climate change. And at the same time, we're speaking about the current effects of climate change on extreme weather, for example. And if we go with those two areas, we see that if we speak about the energy transition, then we do speak about a significant and the material change to the dispute world as we know it at this moment. Even if we are to speak about the huge amount of investment which is needed in order to align the goals, the targets for achieving the energy transition. It is said that, and I'm just mentioning the numbers, that the targets for 2050 are for renewable sources to be around 70 to 85%, or for the electricity generation from gas to go down to 8%, for a steep reduction of in coal, for example, to 0%. Or all those targets do require developments for technologies, do require huge investment, do require huge financing effort for those investments. Consequently, even if we are to consider the number of additional contracts, speaking about, let's say, contracts or regulations or contractual arrangements in the path of what we know at this moment, that not about innovative and new frameworks for contracting. So even if we are to speak about what we know at this moment, it is clear that the number of disputes shall also be multiplied by a significant number. If we add to this the fact that these goals, these impressive investments are also doubled by continuous regulation on the government side, a multiplication of the legal provisions and the entire legal framework for it, it is obvious that we shall be facing, and the arbitration as, again, most preferred way for energy disputes, it will be, we'll be speaking about a significant number of disputes and a significant number of disputes involving the climate change. Another area, so I was speaking about the energy transition and whatever the energy transition means and how this is translated into the disputes field. But we also do see these consequences at this moment. I was speaking about the climate change effects which are being felt at this moment. Extreme weather. Extreme weather, for example, has a direct translation to the construction contracts. The most immediate and the best example at this moment of disputes which are affected or are generated, are multiplied by the climate change, are construction agreements, construction projects, huge projects, which are being impacted by delays, disruptions, debates between contractors and employers on the effect of the disruptive event. If that disruptive event is due to an extreme weather, is this under the normal allocation of risk of the contract or not? So construction disputes definitely shall be reflected and are already being reflected as an effect of the climate change and related disputes. Just a few words on this.
Yeah, I think you've hit the nail on the head that these effects are being felt already. An angle that I think is still playing out in the context of treaty disputes, for example, is you have claims being brought against states for undertaking environmental reform, right? They're already out there. There are a couple of cases with the Netherlands involving, and Germany in the nuclear area. You know, that's already something kind of it's a matter of some concern. The question, I think, and why I think these cases you may find less going forward. People talk about the reform. There are these bilateral investment treaties, the models that are already, for example, the Dutch model, much heavier now on environmental reform. But I would suggest that with the passage of time, these cases should peter out anyway, and for a very specific reason. And that is, since COP21, COP25, COP26, I'd suggest that it's kind of complicated for an investor to say that as a matter of their legitimate expectations in undertaking an investment, they didn't expect the state to step in. So I think that for those who share the concern that ISDS is always brought out as the boogeyman, it's the thing that's going to ruin everything, it's going to hamper states, I would suggest I think that's an exaggerated concern, and that just the passage of time will be one of the reasons that should get sorted out in the mix.
Seems that even the notion of legitimate expectation is changing, because what was legitimate to expect 10 years ago, it's not so legitimate to expect right now, I would say, right?
That's exactly right. And it's flexible. It reflects current mores, right? It's not something frozen in time back in history. It is a mobile concept that should be able to deal with these things.
And if we go to commercial arbitration, there's also the forcibility issue. It is similar to the legitimate expectations, because also in the commercial contracts, in the construction contracts, for example, we're speaking about it was an event foreseeable or not. If the climate change led to the same type of storm for 3 years in a row, it is unforeseeable. It was unforeseeable for the contractor or not. So there are already ramifications also on the commercial arbitration side, not only in terms of international public law.
You okay that I pretend that was my idea?
Absolutely.
I thought that was pretty good.
Absolutely.
Okay, so you have seen how an assignment of IP rights works in practice, yeah, between experienced lawyers, at least. Maybe the force majeure notion is changing as well, because what was used to be not foreseeable in the past now has become foreseeable. Should we go into that kind of speculation?
I think I probably wouldn't frame it as the force majeure notion changing, just obviously force majeure being a sort of creature of the contract. It's just a question of whether or not something is foreseeable at the time or not. And as Luminita rightly says, the more we see these things, particularly in specific regions, you know, for example, the Texan floods, if we see a repeat of those year on year, it's going to be quite hard as a claimant to say, I did not foresee this, this was not foreseeable. So I think that's right. And I think generally, I mean, I completely agree with the point around legitimate expectations, and I've heard people debate whether indeed the notion should move with time, because obviously at the point at which the investor invested, he had a legitimate expectation at that point in time, and why should that then be looked at through the lens of a claim 20 years down the line and the environment that that claim finds itself in? But I think that's exactly how that body of law is intended to work. It is vague for a reason, and states have to have the right to regulate in a way that protects the environment, and that's increasingly the trend that we're seeing. And so I completely agree that that's the way that's going to go.
Yeah, and my point was more about new investments than the evolution. I think you're right. The claimant could say, "Hang on a second, you know, I did this investment in 2004." You know, abandonment, that's an area that's going to become a huge issue, I suggest. You know, well, at the time, there was very little out there on that, and yes, there has been since then, but that's not when I made the investment. Then you get into, like, wait a minute, you've been investing in this project now for 18 years, so what about every new investment? Which I think is one way of looking at the point you made.
Yeah.
Well, one of probably the most important words which defines what we are living right now is uncertainty, maybe instability, which is an equivalent word. What type of disputes should energy companies expect if we can predict, at least in general lines, the future? Michael?
Yeah, I'm sorry, I seem to be monopolizing a bit, but I stepped in to do another one earlier, so it's his fault. Yeah,
you have seen IP rights assignment, now it's blame shifting.
No, it isn't blame shifting. Yes. I'm a lawyer. I think one thing first of all, just one thing we're seeing, and I'm moving a little bit away from the issues of climate and what have you, and that's simply, you know, how's this whole COVID debacle shaping out in the world of arbitration? We've seen, and I was talking to a couple of my partners, we're a big group in Paris, we're about 50 of us in arbitration, and so we get to see a fairly broad range of stuff. We saw a ton of claims in 2020, end of 2020, beginning of 2021, a ton of claims, force majeure, hardship, imprévision, all of these things. But what we didn't really see was anyone flicking the switch. We didn't see people saying, yes, COVID, this is force majeure, bang, let's go to arbitration on this. Most of the cases, I think because the industry was sort of in a state of shock, they just tried to stumble their way through and to work these things out and to make concessions and to really study the question closely. So we didn't see many. I don't know why, but in the last 2 months, a lot have come to roost. We've seen in the last couple of months a number of claims, you know, and the COVID claim, and of course the thing with COVID is that what people are generally complaining about is not COVID, it's the state's reaction to COVID, right? If you're in Shanghai trying to run a business, it's not COVID that's killing your business at the moment, it's the government lockdown. We're seeing that also. What we tended to see with these cases is they started with force majeure, and then say, well, if it's not force majeure, it's hardship. And of course, hardship is very much a civil law notion, not a common law notion, so you'd need to see a clause. One interesting thing, and this happened back in 2009 as well, when there was a bit of as we know, there was a global financial crisis, and people started pulling out their JOAs, blowing the dust off them and having a look at what they actually said for a certain project. We're seeing a lot of that with force majeure clauses now, and we're seeing a lot of force majeure clauses that, lo and behold, are not force majeure clauses. they are hardship clauses under guise of force majeure. There's a couple of cases in France. It was Total versus EDF, where the force majeure clause said, you know, impossibility of performance under usual economic conditions. And that was picked up by the French courts as evidence that this was not a pure force majeure clause. Read the clause. The clause says if there is therefore, if you can't do it under usual economic conditions, that clause is activated, whatever you call it. And we're seeing quite a bit of those types of claims, and I've got a couple on my desk at the moment. I could talk a little bit about the war in Ukraine, but I think there's going to be a discussion about that, so I won't necessarily go there. People have also watched the Nord Stream 2 dispute with some interest now, seeing how that's just stalled. The one area I have to tread a little warily about, so I invite others to weigh in, is, of course, the issues involving Russian gas supply. And the reason I have to be careful is because we're representing two states and a buyer of gas, so I have to try and limit my comments to what's in the public arena. But you know, as you can see, there's now this whole new payment mechanism, and we're still thrashing our way through as to what precisely that means. It's going to be complicated. There's English law out there that's helpful. I'd better stop there, really. But I will stop there and invite others to join in with what they're seeing.
Well, first of all, I'd just echo what you said about sort of late 2020, early 2021 force majeure claims. That's exactly my experience. Force majeure was sort of asserted left, right, and center, but it was very rare to see anyone actually proceeding to arbitration. And that seems to be crystallizing now. And certainly in the case of some clients, I suspect the high oil price might have given them a renewed appetite for spending on litigation and the like. But another interesting thing I've seen in the context of force majeure, and this touches on your point about whether what we're really talking about in terms of force majeure is COVID or the local sort of government actions, the national government actions. And I've seen disputes under contracts where there is a specific distinction in the definition of force majeure between local political force majeure and natural force majeure and different effects, and having arguments about whether we're dealing with one or the other and what the impact is on the parties' obligations under the contract. I'm also seeing obviously a lot around sanctions and the effect that that's having on parties' ability to perform. Interestingly, it's arising most in the context of clients who themselves are not subject to EU, US, or UK sanctions, but who have lenders involved in the project who are, and who are very, very nervous of the situation. And so we're finding we're advising a lot on the effect of those sanctions and the applicability of those sanctions to the clients in question, and just really having to deal with various lenders' appetite for risk around certain investments. And I would also say I'm seeing a lot of sort of joint accounting disputes, so under JOAs between operator and non-operator. I'm seeing a lot of that, which is interesting because in a climate where the oil price is so high, it seems perhaps not obvious that one would spend a lot of time arguing about such things, but I think these are hangovers or hang-ups from sort of the COVID era. And finally, things are coming to fruition or not, and so arbitrations are being started. But I'm spending a lot of time on those issues as well.
Well, we do see you know, similar issues arising. I think that the common denominator for many of the disputes or the pre-disputes, let's say, assessments that we are performing is on a revision of a contract on any form and size of it, being based on force majeure or going on with a hardship or going on with commercial arrangements, not necessarily, you know, falling under one of the legal, but revision of the contract in any form and shape, I think, is the winner of if we are to put a figure on it, and spanning across the industries, being oil and gas or electricity or gas, it's a sort of a common denominator in terms of commercial arbitration. Another area would be disputes commercial disputes this time, not investment arbitration disputes, following the renewables wave, being joint operating agreements or joint or partnerships between different partners. So it's a sort of a M&A, but not only M&A, it goes also into the regulatory side of it. And the last comment, I found it very interesting that you were mentioning joint operating agreements, because that's what we're also noticing, an increase in a number of cases involving joint operating agreement. Of course, Romania is still a producer, a fossil fuels producer, and it may be a reason for it, the fact that there are many perimeters which are under exploration and development at this moment. So it may be the situation that given Romania's specific case in terms of oil production, it is justified. But I find it very interesting that it's a sort of, you've noticed it's a wave, it's increasing, however.
Yeah, and sorry, I was just going to pick up, you mentioned renewables. I was just going to say, I also think in the context of sort of new technologies, so for example, if you look at hydrogen, which obviously has yet to result in a spate of disputes, but wherever you have new technologies and you have new entrants to the market who are not perhaps familiar with the types of issues that arise in energy disputes. So I'm thinking of sort of joint ventures between, for example, in Aberdeen, I think Aberdeen City Council has just signed an agreement with BP for a hydrogen hub in Aberdeen. And wherever you've got sort of contracts like that, where parties are stepping outside of their usual sort of remit or experience, I think there's a real potential for disputes in the future. So we're not there yet, but I think watch this space on some of those new technologies.
Maybe I have a follow-up question. Could maybe inflation could be a factor to aggravate the situation and increase the likelihood of having new disputes? Because if you are looking at the official figures, probably inflation is around maybe 10%, but that seems to be a little bit behind what's really happening out there.
I'd say inflation, but I wonder, and I don't know the answer to this, but you know, are rigs now commanding ridiculous prices? You know, are you now finding that the service industry, having seen what's happened to the price of crude, has suddenly just bang, you know, doubled their prices? And so you've got host states looking at operators who, at the moment, have, you know, let's say they don't even have a cost stop, that they can just keep on reimbursing, have cost recovery before you get into profit share. And if those costs go up, and the state's thinking I have to wait another year or two, that could be. I mean, I saw that about a decade ago, so I wonder if that's happening again, if history is repeating itself.
Is it maybe that we don't fully understand what the risks are? And I'm going to explain a little bit the question. It was somewhere in the news 2 or 3 months ago. I don't know if everybody saw it, but there was a ship carrying about 4,000 luxury cars going from Europe to the US, and now it's on the bottom of the Atlantic. And it seems that the cause, and there was not much discussion about it, it seems that the cause of the incident, let's put it this way, was a fire which was started by one of the batteries to one of the electric cars on board. And it seems that for some technical reasons, this kind of fire is extremely difficult to be put off. Is it maybe that we don't fully understand what the risks associated to the new technologies?
Quite possibly. I was just going to say, there's a local bus depot about a mile from my house, and the buses are all electric, and one of them caught light, the battery, just 2 weeks ago, and then the rest of the buses in the depot caught light, and there was a huge fire that you could see over all of North London, actually. So I think that's a very real threat, potentially. But yeah, I mean, absolutely, to answer your question, I think we potentially don't understand the risks. But hopefully those sort of incidents will be few and far between.
Those with lithium batteries in their phone, have a nice flight.
If we are moving a little bit to the procedural side of arbitration, what types of procedural issues do you think that are likely to occur in energy-related disputes? Luis, can you please help us start?
Sure. Thank you. And I should have said this at the outset, but I'm delighted to be here and to see you all in person. And I have to say, for an energy conference and an arbitration conference, there's a surprisingly high number of women in the room. So I'm delighted to see that. And whatever you're doing in Romania, keep doing it. Well done. So I've been asked to talk about procedural issues in energy arbitrations, and particularly in relation to projects. And conscious that I only have a few minutes, I'm going to focus on 4 of them because, of course, as we all know, many, if not all, of the major institutional rules and domestic arbitration laws provide myriad procedural tools at the parties' disposition. Everything from document production to joinder of additional parties to security for costs applications, for example. But I'm going to start by touching on one that's perhaps a little bit less frequently sort of referred to or discussed, and that's the so applications relating to the parties' payment of the advances on costs that the institutions call for. Now, most arbitration rules, I'm sure you're all familiar with, provide as a default that the advance on costs will be shared 50-50 between the parties to the arbitration. So that's the case for ICC and SIAC, for example. I know the HKIAC rules provide an option in terms of whether or not the institution calls for payment of the advance either on an hourly basis or an ad valorem basis, and the ICC is obviously well known for charging on an ad valorem basis. But the general principle is there that the default is that it's split 50-50 between the parties. However, that is subject to a discretion in most cases for the institution to fix it in other shares. And that's usually to allow for the arbitration to proceed in the event that one of the parties to the arbitration fails to pay its share of the advance. So what I've seen sort of recently is quite interesting. I've seen some examples of tactical sort of maneuvering around payment of the advances on costs. So I'm going to give 2 recent examples. I've seen a case where a respondent refused to pay its 50% share on the basis that the claimant's claims were inflated to the maximum extent. And so obviously, in order to sort of deal with that, the ICC was being asked, and then the tribunal was being asked to sort of dig into the basis for the claimant's claims and to look at the merits. Interestingly, in that case, the ICC, the institution, had already directed the parties to pay in equal shares. And one of the parties to the arbitration argued that in not complying with that, the respondent was actually in breach of contract because the ICC rules had been incorporated by reference into the agreement. And the institution directed the parties to the tribunal, and the tribunal actually said, we're not empowered to deal with this. This is a matter for the ICC, and so ultimately washed their hands of the whole issue. But that's sort of one procedural issue I've seen. A second example of that is a claimant arguing for separate advance on cost payments based on the value of the claim versus the value of the counterclaim. And in that case, the respondent's counterclaim in value significantly outweighed the claimant's claim, although they were both sort of they both arose from the same subject matter. Essentially, the respondent's counterclaim was the corollary of the claimant's claim. Again, in that case, the institution declined to derogate from the 50-50 split, but they indicated that they might do so in future for future advances going forward. So I think that's something to watch out for, particularly in energy sector disputes where the sums, in dispute are vast. And I think we'll increasingly see parties refusing to just pay and comply with this 50-50% split. So the second procedural issue I want to touch on is sort of more widely addressed generally in the writing, and that's bifurcation. And obviously this is a tool where traditionally arbitrations are split between jurisdiction and liability, or between liability and quantum. And it's quite a divisive topic. Some commentators believe that there's value in bifurcation. Others are sort of quite strongly against it on the basis that it tends to just add cost and time to arbitration proceedings. But wherever you stand in that debate, I think it's potentially a useful tool, particularly where it stands to dispose of the whole of the arbitration proceedings if one party is successful. And what I'm seeing more recently is a tendency to use bifurcation, or to seek to use bifurcation, not just in relation to that typical jurisdiction liability or liability quantum split, but to address particular contractual issues or legal issues. And so I've faced a couple of bifurcation applications recently where parties have argued for specific points of law to be dealt with, even where dealing with them wouldn't actually dispose of the need for a full merits hearing on other issues at the end. And so I think that's something else that is increasingly being used, and we're going to see more of that. And there is a history of tribunals agreeing to bifurcation. In fact, in some cases, I've seen sort of 3 levels of bifurcation: jurisdiction, liability, and then quantum. But again, views are split as to whether actually that tends to make for a more efficient or cost-effective process. So the third issue I wanted to touch upon was challenges to arbitrators, which I think we'll probably all agree appear to be on the rise. And obviously that's where a party challenges or brings an application to disqualify an arbitrator based on a manifest lack of independence or impartiality. And it's typically dealt with, well, it depends on the institutional rules, but some rules provide for the institution to deal with the challenge, others provide for the remaining arbitrators, so the ones that are not being challenged, to deal with it. And I think this is particularly relevant for energy disputes because we're often dealing with highly specialized, high value and multi-jurisdictional cases where there's perhaps a limited pool of arbitrators, and so we're likely to see repeat appointments, and in fact we do see repeat appointments. And in that context, I think we're seeing an increase in challenges to arbitrators, whether meritorious or not. And so one example I'll give is in the solar tariff related dispute against Spain brought by BM Solar Jerez. And in that one, I'm sure many of you will be aware, Spain challenged Mr. Tawil, who was one of the co-arbitrators, on the basis of his repeat appointments by investors in similar tariff-related disputes, and the fact that he often, or almost always, dissents in cases where the state has escaped liability. And so Spain was unsuccessful in that challenge, but made a subsequent challenge to the entirety of the tribunal earlier this year on the basis of bias. And the basis for that challenge against all 3 arbitrators is the procedural decisions that they've taken in the case. And that's an interesting one because I think arbitrators and indeed counsel in arbitrations will often accept that procedural decisions are at the discretion of the tribunal and not something on which you would typically ground a challenge to an arbitrator's independence or impartiality. But in this second challenge, in this case, the state is challenging based on procedural decisions such as a requirement. I mean, it's sort of somewhat surprising, but a requirement to file PowerPoint slides a day before the expert's oral presentation, or the fact that the first hearing had to be held in English and not in Spanish, and so apparently the tribunal is biased against the state in that case. And so that's ongoing, but that's just one example, I think, of the sort of the types of issues that are now leading to challenges which perhaps a few years ago would have surprised us a lot more than they do today. Another example of an ICC case in the energy sector involving an arbitrator challenge is the Global Gas and Shell Petroleum case, which resulted in a challenge in the Nigerian courts against, well, an application to set aside the award, essentially, on the basis that the arbitrator was biased. And in that case, the Lagos High Court found that because the arbitrator had been challenged, he should have resigned no matter what. And the fact of the challenge and the lack of resignation meant that he must lack impartiality and independence, and the award should be set aside. Now, obviously, that goes against the IBA guidelines, practice in international arbitration generally, and it's certainly not in line with the leading decision in the UK, the Halliburton case, on arbitrated challenges. But I think we need to be mindful of more of those, and of those being heard in jurisdictions perhaps which, although typically I wouldn't have thought or described Nigeria as not pro-arbitration, but now I will have second thoughts about that. But so that's another example of arbitrated challenges, and I think they're increasingly on the rise and increasingly used tactically. And some of the ones I've seen, if they were to succeed, they would essentially provide a basis to call into question pretty much every tribunal member on any tribunal that's currently sitting. So watch out. Finally, I was going to touch on interim measures applications, and I mentioned this briefly when we were talking about the benefits perhaps of going to court litigation as opposed to arbitration. Notwithstanding what I said earlier, obviously you will all be familiar with the many interim and conservatory measures that are available under most of the institutional rules. And I think there has been progress, certainly with the emergency arbitrator appointments that are now available under most of the rules, which cut through some of the delay that one experiences in constituting a tribunal. But nonetheless, I think there are instances that remain particularly relevant in the energy sector where really the only thing that will do is a court injunction, because you can get it ex parte, you can get it quickly. And so I'm thinking perhaps about interim measures where you might be trying to prevent the call on performance security, for example, or a guarantee. And so one example I just wanted to mention was a Seadrill and BP case, which is a 2020 New York-seated ICDR arbitration, in which the Seadrill entities actually filed for bankruptcy during the arbitration, and the tribunal granted an interim measure to BP providing for security for costs, particularly in view of obviously the insolvency of Seadrill. Second example, more recent, in April 2022, the tribunal in an ICC case relating to a gas and fuel power plant issued a procedural order for an interim measure to protect the status quo. And that one was issued after the respondent in the case had called on a bank guarantee, and prior to calling on it had threatened to do so if the claimant didn't sign certain settlement documents. And so in that case, the tribunal ordered the respondent to withdraw the call immediately, and not to make any claim on the guarantee. So there are cases in which interim measures are effective and are granted, but generally speaking, certainly in my experience, they're only likely to result in a sufficiently speedy result if you have a tribunal in place already. And the emergency arbitrator route, although better than nothing, is not necessarily ideal. So, I mean, I've been involved in a case just in the last month, and I'm just going to mention this because the complexity of some of these issues, it sort of sets them out. And I challenge you to follow this after lunch. But so the claims involve the alleged termination of a bareboat charter, which provides for arbitration of disputes under institutional rules. And so one of the parties to the bareboat charter applied for an emergency arbitrator in order to then apply for interim measures to restrain the other party from essentially treating the contract as terminated and taking various steps as a result of that. In the meantime, a related application to arrest the vessel that's subject to the contract was made in the national courts elsewhere, resulting in the party that had gone to arbitration and filed for an emergency arbitrator seeking an anti-suit injunction against the national court proceedings to restrain the vessel, and then the other side seeking an anti-suit injunction, which I'd never heard of until 3 weeks ago in practice. But anyway, so a mess, but I think it just goes to illustrate that there are occasions where you need the speed of resolution of court proceedings, even with all of the downsides that may come with that in terms of enforcement, etc. And I think the last thing I'll say is just in the context of third-party funding as well. I think we see, third-party funding is on the rise, and I think we are going to see increasing challenges resulting from that. Obviously, the ICC rules now provide that parties must disclose the existence of a third-party funder. And I am seeing increasingly, whether it's under ICC rules or other rules, tribunals providing in the first procedural order or in the terms of reference for the parties to disclose at any stage in the proceedings the existence of a third-party funder. And I think there have been some recent cases, which I won't go into now because I don't think we have the time, where arbitrators have been challenged, particularly one case in particular where an arbitrator was challenged because of a role that he had on the investment committee of a well-known arbitration and litigation funder, and having not disclosed that as part of his disclosures on appointment, even though that particular litigation funder was not at all involved in the arbitration in question, but that funder had funded similar cases, investor-state cases involving similar issues, and so the argument was that by virtue of his double hatting, should we say, sitting on the investment committee for the litigation funder, he must have been involved in discussions and taken a view on certain jurisdictional arguments that were relevant to the case in which he'd been appointed. So yeah, I will leave it there and see if any of my panelists have any comments.
Anything to add?
Yeah, that was great. That clearly, I mean, I enjoyed that, and that's sort of bringing up issues that really happen and that only players really get that. A couple of very brief points. One was on that whole question of the ICC advance on costs. There is authority under French law to suggest that a party that doesn't pay its share may be held to have given up its right to arbitrate, whether it's on the basis of procedural good faith or renonciation, whether waiver of a right. So some people might find themselves shooting themselves in the foot by trying to play that game. The other point, it's really a detail, it's a subset of what you'd mentioned, but it's something I've had to come across a couple of times recently where I've been asked to be an arbitrator in some of the Spanish gas cases. This is just gas pricing. There was an arbitrator and an award which I believe was set aside because the arbitrator as counsel had worked with the other side's expert on a number of occasions. So when you're sitting as an arbitrator, one question you may want to think about if you do a lot of work as counsel is who are your experts? And that was something I had to look at. And as I say, in my recollection, well-known arbitrator, the case was overturned. That's it.
Well, just a couple of ideas. Out of the four major items you have listed, I really found most disturbing challenges and bifurcation. Challenges because it's it may get you to the end of an arbitration, and after 3 years of fights and seeing the light at the end of it, you actually get into this. And sometimes what I've noticed is that the reason for challenges are not necessarily bad faith. If you end up discovering that actually the arbitrator did not disclose a particular relationship with another co-arbitrator or with a particular party, for example, and this was not disclosed at the beginning of the arbitration, that's a huge issue. And it's a problem also for a counsel who had recommended that particular arbitrator. So what if there's an extremely high level and maybe not necessarily very sophisticated piece of advice here is to for the check and for the recommendation and for the arbitrator's disclosure at the beginning of the arbitration to be more comprehensive, if this is possible, in terms of English language, and ongoing and definitely ongoing. So there is some sort of a practical advice here. The other one with the bifurcation. I've seen one of those extreme cases in which there were 3 levels of bifurcations: jurisdiction, liability, and quantum. And then there were at least 2 or maybe 3 partial awards on quantum, which goes on having at least 5 or 6 partial awards. that's also an extreme situation. And while bifurcation may be a useful tool when indeed the issues are determinative, and if you get out jurisdiction, indeed there's an end to the arbitration. Situations when you have jurisdiction or partial jurisdiction, and then irrespective of the award on jurisdiction, however the arbitration moves on, it's one of those examples when you actually have at least 2 years added to the arbitration unnecessarily. Again, I think that there are many, and there are many gray areas. There's no white or black situation always. There are many gray areas, but on each of them, a better approach or a more careful approach at the beginning of the arbitration, and as Michael was saying, continuing during the arbitration is actually recommendable.
Thank you.
Oh, sorry.
Please.
I was just going to come back on the point you made about arbitrator disclosures, and I 100% agree that obviously it's much better to sort of disclose. So if in doubt, disclose, obviously, because it's ultimately in your client's interest, your party's interest, because at the end of the day, you're more likely to give them an enforceable award and to minimize the risk of challenge down the line. But one thing I will say about that is in the context of sort of first appointments, and I see we probably have some of the younger generation in the room, I think a lot of the first appointments, certainly my experience of my first appointments, came from institutions, not from parties, and the institutions are incredibly conservative in terms of who they will accept and appoint. And so I had a very frustrating period of about 18 months before my first ICC appointment, where I made the most conservative of disclosures along the lines of, you know, one of our offices in Texas once acted for a party in a transaction that is named as a related party to a third party in the request for arbitration type thing. And that resulted in, sorry, we won't appoint you. So I think we also have to think about what that does in terms of sort of working against our desire to diversify the pool of arbitrators and allow sort of younger, fresher faces in the door. And that's a difficult one to juggle, but I'll stop there.
Okay, a lot of interesting ideas. I would have some follow-up questions, but I will refrain myself from asking them because we still have Yaroslav online. Yaroslav, please, your turn.
Hello, everyone. Thank you very much for this opportunity to participate at this conference. Unfortunately, I could not come in person. According to the martial law, most of the men in the country are not allowed to travel abroad. That is why I have to broadcast from Kiev, where I arrived last week after 3 months of absence due to the war. I hope that you hear me well and there are no technical problems. And if everything is fine from the technical point of view, so I will, in my presentation, cover several items. And so first of all, I would like to speak on impact of the war on the Ukrainian energy sector, and also some of the impact which Europe is facing, and maybe not only Europe. And also I will try to cover some of the aspects related to, partially related to dispute resolution. It is damages recovery as a result of the war, and what options exist at this stage for this purpose. So turning to my next slide, I would like to say a couple of words about Asters. Asters is the leading Ukrainian law firm. It is the largest one. It is the largest one, and it is full service, and it has top-tier energy practice on the market, and it is also has JAR 100 recognized arbitration practice. So next slide, please. So now I would like to speak about the situation in the energy sector before the war. Next slide, please. Before the war, the situation was very promising. And Ukraine has been one of the largest transit countries for gas to Europe. It was the country which actually was a reliable partner for the EU for the transit of natural gas, despite of some actions of Gazprom and Russian Federation. And also Ukraine has a very strong power sector with a lot of nuclear power plants, and they also provided a lot of sustainable and effective power. And last year, 50% of our power was produced from nuclear energy. And also, Ukraine has been taking very serious actions with respect to coming and transferring to the green energy. So we are also committed to the actions under the Paris Climate Agreement. For the last 10 years, Ukraine has been very active in building renewable energy projects. So we had, before the war, we had almost 10 gigawatts of renewable energy. And just for your understanding, it is more than 10% of our energy balance. And this has been done due to subsidy programs provided by the state, and so it has been a good investment climate for our country. And there was multi-billion investments, and the industry has been growing, and our law firm and myself have been very active in renewable energy before the war. And if to look into the situation now, please turn to the next slide. And after the war, the situation has changed, unfortunately. And next slide, please. Yes, actually, after green fields, you can see now the burning turbine. Actually, it is a turbine of our client Windcraft, and it was one of the first turbines which was burned during the first days of the war. And I'm currently placed in their office. And there were disruptions, and as a result of the war, basically what happened. So right now, most of the renewable energy facilities which are located in Ukraine, they don't operate. And because most of them has been located in the south of Ukraine. And right now, active military actions are taking place there. And in this situation, they have been either destroyed partially, and right now we know about at least 5 instances of destroyed wind power plants, wind turbines, and also destroyed substations and destroyed infrastructure of these projects. And in this situation, we of course also see a decrease in the production of renewable energy, and you can see the percentage for how much the production has been reduced. So, this sector has been impacted significantly, and a lot of private investment has been destroyed, and basically great impact. Next slide, please. And on this photo, you can see a substation of our client, which has been hit by a missile, which was not targeted directly to the substation, but we understand that most likely it has been targeted. The explosion took place because it was flying at the low level and just touched anti-light equipment and exploded. But yesterday I met with a client, and at the same substation, another missile came, and it has not exploded, but still it shows that it is under heavy attack. And what I wanted to say, so basically, many of the facilities are destroyed, or if they're not destroyed, there are situations of thefts of equipment and vandalism. For example, for one of the largest wind power plants, the dispatcher center was completely kind of destroyed in terms of everything was stolen, all the computers and equipment, so it cannot operate in this situation. But even for those power plants which are operating in Ukraine, there are right now difficulties with respect to payments. So due to the martial law, the government reduced payments for the feed-in tariff, and companies are now receiving only up to 15% of what they were supposed to receive, and this actually amount of money which is required just to pay salaries and for some maintenance. But many companies are at the bankruptcy level. Also, there is a high level of curtailments on the market because the power system has been kind of affected by the military under the military actions, and the level of consumption also reduced, and it creates a lot of problems. But on the other hand, there are some positive things. During May, more energy was produced from cleaner sources compared to last year. Next slide, please. Yeah, coming back from situation which we have at the moment, if to look into the plans, what Ukraine is considering to do. So of course, in this situation, it is a good investment, and every difficult situation is an opportunity. And the opportunity is for Ukraine is actually to shift from conventional energy sources to renewable energy, and we have a good success in this, and we have a good potential to grow further. And so the renewables will grow for sure after the war ends. And in this respect, also in order to have some plan for the post-war reconstruction, our Ministry of Economy is working on the plan which will help to tackle these problems which exist at the moment. So, and they are looking into several elements how it will work. So it will be achieving energy independence, mostly through the means of increasing production of oil and gas in Ukraine. Ukraine has very good sources of oil and gas, it just need investments to do it. And also building of nuclear power plants, which will help. And another aspect is climate modernization, so it is moving to renewables, reaching Green Deal targets. Next slide, please. And also there are opportunities with respect to cooperation with Europe. In this situation, under the hostile emergency situation in March this year, Ukraine joined INTSOE. Ukraine still was going to join INTSOE. I mean that the idea was to integrate Ukrainian power energy system with European. Before it was synchronized and connected to the power system of Russia and Belarus. And now our power system is connected to the EU system, and our networks are working in parallel, and they can cooperate. In this respect, there are opportunities for cross-border trading, and our electricity from Ukraine can be exported to Europe, and they have been used yesterday that very shortly there will be first commercial trades of electricity from Ukraine to Europe, and the auctions will start soon. So it is a great potential, and we already have clients who are interested to set up companies in Europe and become a trader there. So there is a certain capacity for this purpose, and it will be increased. There are plans to build and upgrade existing power lines. So it is actually what will be happening, and after the war we also see the potential for building offshore projects and also hydrogen projects. And for this purpose, increase of the cross-border capacity between countries is very important. Next slide, please. And coming back from situation in Ukraine, I wanted to say about what is happening in Europe. So what is the impact at this stage? So we see the reaction of different and separate countries with respect to what has been done. So Poland, for example, they terminated the contract for transit of gas, which was effective until end of this year. So Lithuania also refused to have any energy sources from Russia. Denmark is also increasing renewables in their portfolio, and so separate countries are working on to become more independent. And in this respect, we see the initiative which was adopted in March, Repower EU, which is also aiming increase of the renewable energy balance in the EU, and that more targets should be taken in order to reach green energy. And on the other hand, we see that there are attempts to impose additional sanctions, not by independent countries, but as by EU themselves. And in this respect, it is we see that there is a ban for bringing coal from Russia, and also there are constant discussions on oil and gas embargo for bringing it from Russia. So there are more actions are taken by many countries in order to provide it, but still we see that some of the countries are trying to block some of the decisions. Next slide, please. And we see that that countries are working more and more on different opportunities in order to become independent. So that we see many examples of cross-border cooperation with respect to enlarging capacities, interconnectors for electricity, for gas, and we see that many companies are also refusing to buy gas and pay rubles for this. And we see that there are opportunities and attempts from different countries to diversify their energy supplies. And also a great part will be for LNG development in Europe. Next slide, please. And with respect to LNG, it is evident that there will be new facilities built in Europe, and we see that it will be a great source for diversification. And Ukraine also has been considering options, and we have been involved into a project analyzing how to bring US LNG from Poland. And I understand that there will be more and more such projects, and we see that some countries are considering purchasing floating LNG terminals, and so it is also a big part for our future and the new reality. Now turning to from kind of the situation and impact on the energy, I would like to go to the situation what we face with damages, what has been caused by results of this military operation. So please turn to the next slide. And in this situation, it is quite challenging because we have clients who has been suffered, and there are many companies who suffered the results of this military operation. And in this respect, we should follow several steps. And of course, it is very important to collect evidence on such damage. And unfortunately, kind of there is no exact rule procedure how to document this damage under the military operation, because everything is new and legislation is adopted very fast, and in order to adapt to the situation. But of course, as lawyers, we recommend clients to take at least first reasonable actions in order to collect information about damages. Then coming to the stage of recording damages, we rely on also different options in order to arrange expertise of certified experts which can confirm that the damage took place, because we understand that at this stage it is very important to have a report confirming that damage happened during a specific period of time, and that it was caused by military actions. But also important to mention that the government already approved a procedure how to document damages, and it is also important to follow this procedure in order to comply with the provisions of Ukrainian legislation. And the legislation is changing quite often, and kind of we rely on this as well. But with respect kind of to next step, how to protect and how to get the compensation, it is the most tricky part. And if we can document damage and have it and produce a report by the Ukrainian expert or international experts in order to protect the interests of the company in the future. But the real challenge is where to go to claim this compensation. So there are options either to go to courts. So easiest way and the most evident is to go to the national courts of Ukraine, because damage was done here. Another option which has been considered but has not been tested, it is actually coming to courts of foreign jurisdictions, relying on their specific legislation on protection in situations similar like this, based on the terrorist acts and etc. And of course, there is the opportunity to go to the European Court of Human Rights, but unfortunately, this option is available only until September this year, and I will tell about this on the next slide, please. And of course, if we decide on these options, we should really think that whether these options are practical. And unfortunately, we come to the conclusion that none of these options is practicable and efficient in this situation. Because if we look into, even if we get a ruling of the Ukrainian court or even a foreign court, still we will face the issue of sovereign immunity at the stage of enforcement of such decisions. And in this situation, kind of, we don't advise clients to go to Ukrainian court just to get a favorite ruling and to have it in the shelf. No, we should look into more pragmatic solution. And unfortunately, also the option with European Court of Human Rights does not work well as well because of the actions of the Russian Federation, and unfortunately they have decided to leave the Council of Europe and also identify the Convention for Protection of Human Rights and Fundamental Freedoms. And also there are some actions on the legislative level in Russia where they are trying to ban enforcement of such decisions. So of course it was an example like with Crimea cases when Russia was taking hostile actions with respect to potential enforcement. This situation is similar. So, and also if to look into the opportunities, if to go to into investment arbitration and BATs, also it is not clear whether it will be possible because as it was stated, as it was tested with Crimean cases, the jurisdictional issue are also quite important in order to confirm that whether the investment took place and whether it was covered by the BAT. So many questions, and the situation is that unfortunately there is no kind of clear picture how to do it, and so we need to look into alternative options how to get the compensation. Next slide, please. And in this situation, we should rely on other sources. For example, the European Commission adopted in May of this year work plan. Please, next slide. They adopted a program for how to fight with the results of the war, and they adopted post-war recovery plan, and according to this recovery plan, there would be money allocated in order to protect and compensate damages, which is one element which exists. Another element which is already tested and which is working, energy community, which is part of the EU institutions, which is responsible for helping Ukraine to bring its legislation into compliance with the EU standards. They set up, based on the request of the Ministry of Energy of Ukraine, support task force and also Ukraine Energy Support Fund, which are actually like facilitators and agents in the situation and the bridge between different donors and suppliers. And so they help to arrange that the help which is provided and donated by governments and private companies is reaching its companies who have suffered. So it is an important element, and we have now situations when this mechanism has been tested and money has been donated and companies has received them. And also still under discussion is sort of establishing a separate fund and which will be helping to recover the damages caused by the company. So it is kind of still on the table, and it will be progressing and it will be developed. So on the Ukrainian level, international level, many actions are taking place, but in terms of legal mechanisms, in terms of dispute resolution, unfortunately, there are not that many options. So currently, we rely more on alternative ways in order to compensate the damages. So from my side, this is all. I would be glad to answer any questions from the audience or speakers. Thank you very much.
Thank you. Thank you very much. Inevitably, we are running out of time. I don't know if we have permission from the organizers to open the floor to questions from the audience. We are happy, I think, with either scenario. I'm not getting any. So being mindful of observing the schedule, we will stop here. Personally, I had no doubts before hearing our panelists that arbitration should be the preferred form of dispute resolution for energy disputes. I hope that everything that we have heard today would confirm that conviction that you already have. I have no doubts since you are here. It's a little bit of an worrying trend, what I have heard, especially from Luis, that we have a lot of procedural challenges during the arbitration, maybe after the arbitration, because this is not something good for the process and for the trust. The arbitration process is something that is built on the parties' consensus and trust. And once you don't have that anymore, arbitration as an institution suffers. Fortunately, we have the mechanisms, we have the procedures, we have the knowledge to deal with this kind of matters. But it's something that we as counsel and arbitrators in our various capacities, we should keep this in mind whenever we are involved in arbitration in order to build on the trust which the parties already have and they should continue to have in the future. Thank you so much. I was privileged to be able to be the moderator of this panel, and see you later.
Thank you.
Thank you.
Hello, everyone, and thank you to all the participants that are still present in the room for your patience and for your dedication to the arbitration, which is the one that made you stay up to this late hour in the afternoon and after the lunch to enjoy what I think it would be one of the most interesting panels that you'll have today. And I say that for sure because the speakers in this panel, all of us are legal professionals, but the speakers in this panel have something in addition. They all are coming with a very particular background from the clients that we are serving through the means of this wonderful alternative dispute resolution procedures. So without further ado, I would like to first of all let you know that my name is Sorina Olaru and I'm a partner with Nestor Diculescu Kingston Peterson. So I would like to make a correction of whatever it was written on your panels so far. And I would like to introduce our speakers. They come from diverse backgrounds, from diverse industries, and they are here to share with us their experience in relation to the energy disputes and energy arbitration. And I think I would start in alphabetical order with Mrs. Adina Guțiu, sitting on my right. And she is a business lawyer with more than 13 years of experience in international law firms such as Linklaters and Schöner. Also, she is having at least 6 years of experience in one of the most prominent players as general counsel in one of the most prominent players in the oil and gas industry acting on Romanian market. And she also is associate professor with the Bucharest University of Economic Studies, teaching students business law. Welcome. Then I will turn on my left to Mrs. Alina Dumitrașcu. Mrs. Alina Dumitrașcu is coming from a very well-known company of electricity in Romania, Enel. She is the head of legal and corporate affairs of Enel Group. She just recently occupied a global position in Enel Group and she has a lot of experience dealing with energy disputes and energy in general, energy disputes, energy arbitration, not only energy disputes. And she is also involved in teaching in a very playful way principle of constitutional law to the younger generation. She is the author of a book called What It Is, the Romanian Constitution. Let's play and we'll find out. And it is a personal project that came to life for several years now. Then I will turn to Ioana Nol-Tudor. Ioana Nol-Tudor is a partner with Jeantet. She is the head of the Budapest office. She has also an extensive experience in investment arbitration and in commercial arbitration. She's also an arbitrator. So we have the perspective of both the users and the arbitrators in this panel. She is currently lodged in Paris, and she is one of the most prominent Romanian female arbitrators abroad. Thank you for joining us. I will turn to my right again, and we will have on my right Sara. Please tell me if I'm spelling correctly your name, Sara Coleilalt Aranjo. Sara is coming and she will provide from Alta Mimi. She's a partner with Alta Mimi in Dubai, and she will share with us her experience and expertise in terms of arbitration that she offers, having in mind a completely different system of law and a completely different and diverse expertise. Thank you for joining us. I know that you just come from across the ocean recently, so thank you very much for joining us. Then I will turn to my left again to Mr. Filip Neagu, who is the Vice President and General Counsel on legal side of OMV Petrom, the national and the most important player on the energy market in the oil and gas industry in Romania. And he has an extensive experience in terms of not only leading teams of professionals in the legal field in both upstream, downstream investments and everything that it's dealing with the energy. Thank you very much, Philip, for joining us. And last but not least, I turn to my right again to Florian Kahn. I was impressed by your motto, Florian. The rule of law is not negotiable. Florian is coming from Framatome. For those of you involved in energy business, you know very well that it is dealing with nuclear energy and nuclear equipment. It is a company, and please correct me if I'm wrong, Florian, owned by EDF and
yep.
by
ultimately by the French state, but
and
in between
by the French
EDF,
state,
yes.
So now you can see that we have the nuclear energy represented here, the electricity represented here, the oil and gas industry represented here. So all of them are ready to share their experience with us. So without further ado, I will just browse through the questions that we would intend to address during this brief session. And I'm sure that some of them would require further discussions. Unfortunately, not all of that would be able to be touched in this limited time. One of the things that we wanted to share with you, or we wanted to discuss, is what's the view of the energy sector on arbitration as mean of solving disputes. Does it meet the user's expectation? Does it meet the, is it a typical tool used by the participants to this energy market? Is one size fit for all disputes that are used in this or appear in this market? And I will turn to Florian first, because I turned last in presenting you. So please.
Thank you very much, and thanks for having me on this panel. I want to, in this context, I thought it very helpful, a couple of things that Michael Polkinghorne said earlier today about what we perceive as the advantages of arbitration over other means of dispute resolution. And I want to add a couple things more, maybe. One of them is indeed predictability as to the procedure. International arbitration, especially institutional arbitration, is something that has, although a lot of people talk of flexibility, has certain rules that you can rely on, and then you have certain iterative steps that you can plan your proceedings also with regard to the internal contributions, and that is especially when it comes to large energy and engineering arbitrations, a big factor. The other part is the scalability of arbitration, because if you think about a large project that has several layers and several tiers, a supply chain that spans possibly a lot of jurisdictions and continents, then it's very difficult to have distinct dispute resolution mechanisms for each and every one of those contracts. So those are two aspects that I think speak in favor of using arbitration in this context, and therefore it's no general surprise to me, although I didn't know those statistics, or not the recent ones, that energy and engineering rank #1 in the ICC arbitration statistics. That is no surprise to me. Maybe I'll leave it at that, and then I'm interested what the others have to say.
Sorry, is it a tool that you're using a lot, and if so, would you considering adequate, and where in particular?
Thank you. Very good question. But let me start by actually thanking the organizers for this event. It was a really very nice pleasure and a very good surprise to me to to have such an event in Bucharest. Tomorrow there's I understand a panel on climate change. So really really grateful to see that. On to the question, I would start first with painting a bit the big picture and actually replying on the broader question, where my answer is a clear yes. Arbitration, especially for oil and gas, arbitration is an appropriate tool. There is a very solid practice of already tens of years in the field, and with very very well established practices and professional across the world, very much experienced, and those aspects are contributing to actually two of the key elements that mostly energy companies are or investors in major energy projects are looking for, which is predictability and stability, as also Florian hinted. And I mean, those of you that are a bit familiar with the Romanian landscape, I think I could have named my children predictability and stability, because I've used those terms so much, probably more than my children's names. So, and then moving to the Romanian market, I would say it is a tool used so and so. It could be used a lot more, and I think the tool would serve the interests of all involved parties. But when we're talking about national markets or certain markets, it's not only the arbitration per se that we have to look at, but it's also the legal system in which the arbitration is happening, the exact institution, and so on. I'd say, and I would wrap with this one, quite encouraging signs in the last year, also in this institution that we are here now, and yeah, I'd say the future looks brighter and brighter in this regard. Thank you.
Thank you, Philip. Alina?
From
I think it is a one size fits for all.
No. No, and everyone knows that NR was involved in a lot of arbitral procedures. And yes, it is a solution when it's not emergency and it's not an excessive regulation of the markets. Like during this period, we have this energy crisis, and every time an authority or an institution is issuing something, and I think in that moment you have to go to the local courts and trying to obtain something in an urgent way, and the arbitrage unfortunately is not moving as fast as the user is needing. Also, when you go in the local courts, maybe you can go up to the constitutional courts, and I see here in this room young people, and maybe a lot of them know that a very important case was ongoing until last year regarding the natural monopoly in the energy sector, and in that specific case, the local courts were issuing a decision, and also the Constitutional Court expressed an opinion. And speaking about what is one that fits to all, I must say that if we are thinking about this principal court case, it was ruled by the local court, so you cannot go every time in this direction. And even though we didn't use too often the infringement procedure, I think sometimes it's also about infringement because we are focused on renewables. We are trying to somehow to help the authorities to transpose the legislation issued by the EU, and if something is not going so well, maybe sometimes also infringement could be a solution. And not least, I don't know, going in the local courts, you have the way in going up to the European Court of Justice with a preliminary question, and sometimes it is about it in order to solve a normative issue.
Ioana, do you have a different opinion? So obviously there are administrative disputes where states are maintaining their monopoly in terms of jurisdiction. And I think that that's the same in Romania as everywhere else. But other than this,
I only had two comments to make. First of all, I'm extremely happy to be here, and I really want to say that we had a wonderful time with the panel preparing the session. So I just wanted to thank all the panel members because the pre-session was extremely exciting and interesting. So I have two comments to make. The first one, to Alina's comment, I think the European Court of Justice is certainly a good idea. The only thing is that we all know the ECJ uses not to answer the question which is asked. It's often, I know this is not the question, but this is my answer type of thing. Now, on the more serious side, the national courts fully agree. But then I also think that we have to keep in mind that depending where you are, in what jurisdiction you are, and how the courts of that jurisdiction are functioning in terms of course, being busy, but also in terms of independence. And I think that not only in Eastern Europe, but we do have in the world jurisdictions where national courts may be problematic to use. So fully agree with Alina in those jurisdictions in which the courts, national courts are available and ready to do the job properly, yes.
I see. Sarah, what would be the MENA perspective and the history of using arbitration in
Thank you, and good afternoon to everyone. And I'm extremely privileged and honored to be with you here today, joining from Dubai on this first time visit ever to Romania. So it's an absolute delight, and I concur with what Ioana has mentioned on the wonderful pre-prep sessions that we had. I think just to backtrack a little bit, even though I think all of us generally have a consensus and the statistics, as was mentioned, sort of support this, at least at the institutional level. I don't think that if we look at the history and we backtrack for like a century ago, that arbitration really was the more or less preferred method to resolve energy-related disputes. And if we go back to the post-World War II era, we would notice that this particular era has, in a way, fueled the resort to arbitration, which was not the case before. And this has been primarily related to, obviously, growing sophistication of the economy, diversification of the resources, and obviously a lot of interplay of regulatory and geopolitical factors that would come into play and that we see even until today affecting the overall framework in which energy is, on one hand, produced and then supplied. And obviously, energy plays a crucial role in day-to-day economy and has been at the crux of political tensions globally, as we are seeing also very recently. However, I would have to say that energy disputes also have played a significant role in shaping arbitration as we know it today. And by arbitration, I'm referring to both commercial arbitration, but also investor-state arbitration. So when we talk about the modern arbitration, which is the one stemming from the last century, 20th century onwards, we could see that at least the investment protection system has and is actually indebted in large to its development to the specific arbitration cases that relate to energy. Because on one hand, they have helped shape or institutionalize a system at least on the investor state side. And they have helped also shape the standing of private investors in view of also seeking recourse against states. And for the commercial parts as well, we've seen as well for the very limited type of arbitral awards that were published, I'm talking about the commercial arbitration arbitral awards, we've seen also a fine-tuning in the way as well arbitral jurisprudence in a way is formed. Now going back to the Middle East, as many of you know, the Middle East region, and particularly the Gulf Cooperation Council region, the GCC, which for those of you who are not very familiar with it, is a state or is a governmental association of 6 countries in the Gulf. And the primary producers of energy are Saudi Arabia, the Kingdom of Saudi Arabia, the State of Qatar for gas, as well as the United Arab Emirates, where many of you can be familiar with ADNOC, which is one of the largest oil producers in the world, which stands for Abu Dhabi National Oil Company, and Aramco, which is the Saudi Arabian oil company. And going back again to last century, the Middle East region has had a very challenging, or I would even call it tumultuous, hostile relationship towards arbitration. And there was a very known decision in 1951 in a case called Petroleum Development versus the Sheikh or the ruler of Abu Dhabi, where an English arbitrator has not necessarily made a very appealing ruling through misapplication of Islamic Sharia principles, and which has left a very tainted mark, which I'll go back to later on today in our discussion as we discuss more certain regional specificities on the relationship vis-a-vis arbitration. That is not to say that today arbitration is not back on the agenda, and that is mainly fueled by foreign direct investment considerations, but that is to say that the relationship has not been an extremely smooth one at its origin, and which means also that even though the MENA region is one of the fastest and growing and biggest producer of energy globally, there is not necessarily a positive correlation. It is actually a negative correlation between arbitration statistics and MENA region, because there are other forms of ADR that are often preferred, and I'll come to that later on today. Thank you.
Thank you. Coming back to energy arbitration, does it have additional feature in comparison with arbitration in any other field? Is energy arbitration even a thing in itself? Ioana? Or anyone else, if you would like to join to the debate.
I have the floor, I take it. So I'm going to answer this one because I've been giving some thought, and I think that what has to be said is that historically there has been a number of cases in the energy sector already, but today when cheap energy and easy to get energy is not really there anymore, I'm sure that we will have more and more energy cases available. But if we look at the statistics as of today, just looking at the numbers, in terms of the ICC, for example, just to take an example, there have been in 2020 167 cases related to energy out of around 1,000 cases that they have. The number may seem small in comparison to the total amount of cases. However, this is the first biggest sector in terms of disputes in the ICC. In the ICSID, because we were all talking about ICSID as well, in the ICSID also the extractive and energy sectors have been those which gave rise to most or to many cases. And actually this is a trend which continues also in 2021. If you look at the report of ICSID for 2020, 29% of the cases are in oil and gas and energy, and 14 are in electric power and other energy. So this is also, in terms of ICSID, the largest share of cases in a sector. So clearly there is a big share in these institutions of energy disputes. Now, I ask myself, what is what are we talking about? What are the energy disputes that we are talking about? And actually, if you look at it, it's difficult to have a typology. I was aiming of having a very clear one, but you do realize that there is a variety of energy disputes out there, and it can go from international boundary disputes between states, which also are in certain cases energy related, because you can speak about maritime waters and the oil and gas fields over there. You can speak about offshore wind farms, for example, often also giving rise to discussions, but also maritime delimitation in terms of exclusive economic zones. But then you can also have something more traditional in a way, which is gas price review, for example. It's also an energy dispute. You can also have engineering and construction, energy infrastructure issues, defects, delays, etc. And of course, and Alina, you're mentioning it, I think you can also have a lot of state measures or adverse government actions. I'm not going to speak about that a lot because I'm sitting as an ICSID arbitrator in one of those cases, but you do have Spain, you have Italy, you have a lot of cases in ICSID now dealing with that, so that's also something to look at. And very interestingly, I think, with the renewable energies, we also have some more specifically related to renewable energies disputes, and this I would only quote two. The first one is performance issues with new technologies. And we do have, especially in the offshore business, those who work on that, it's very innovative, it's very interesting, but of course, because it's innovative and interesting, you also have a lot of performance issues often with that. And of course, delays in connection to the grid, for example. That's also, so what are we talking about when we speak about energy? I would say a wide variety of disputes. This is probably what also explains the number of disputes that we have. Now, your question was, is there any specificity? And I would say that the specificity is that compared to other industries, energy really has an inherent exposure to geological, technical risks, social and political ones, but also there is a lot of scrutiny by the public. And this is also something to mention. So there is a lot of valuations and changes in the market, which I think is really something that the energy disputes have in common. Louise, I think, was speaking before on the other panel about specificities more in terms of also of procedural issues, etc. So I'll not enter into that. The only thing I wanted to say is that I think the variety in terms of disputes and also these inherent specificities, social and political, a lot of scrutiny by the public, etc., is really something that is inherent to the energy market.
You mentioned earlier the investment arbitration in this field. I was wondering for EU states how the investment arbitration would look like, and I will turn to Florian. In an era post-Acmea and Comstoi. Because we heard Petra this morning mentioning a variety of issues in relation to this.
No, I just want to quickly, before I answer that question, or before I give my 2 cents on that, I want to quickly pick up on the specificities of energy arbitration that Joanna alluded to. I think, and that's also a good segue to investment arbitration, because indeed, I think, and I think everybody knows the industry that I come from, I don't think you can get more scrutiny than that in the public eye. I think ever since the Fukushima accident, everybody knows, and it's beginning to shift again. I'm digressing a little bit, but it has to do with the topic. It's beginning to shift, you know, after Fukushima, we're kind of the bomb builders, you know, and now we're, you know, moving towards, you know, one of the solutions to the energy crisis. So I'm no alien to public scrutiny, and I think this is a very important aspect also for the development of investment arbitration. Now, I'm not an investment arbitration lawyer per se, but what I'm witnessing, also talking to state actors, which I do frequently, it seems like the public pressure that has been exerted on the energy sector is moving the whole energy sector away from privatization again to a very important pillar of of state governance and state intervention, which then also extends to the legal sector, which means that states are more and more reserved against investors telling them what kind of policy they're supposed to be making in the energy sector. And that translated first into a very strong stance of the Commission in Europe, and then percolated, let's say, around the Attorney General, who had a different opinion, into the decision of the courts. And I find this a little bit worrying, because, as was alluded to before, there are jurisdictions which, for various reasons, are not yet ready to within Europe, and there are jurisdictions which are actually under scrutiny of the Commission itself for not being able to follow the rule of law. Thank you very much for the introduction. While at the same time, the Commission says, well, we trust those courts with making impartial decisions. That, for me, is, well, at least it raises some eyebrows. And so I believe there needs to be some sort of place for investor-state arbitration still also on the territory of the European Union. It's right now not looking like that. And if you look at the Antitrust Working Group 3 that I'm an observer of, it seems like we have a very lopsided discussion there. So I'm not particularly optimistic, but I think there's especially because this has so much scrutiny and therefore so much tendency to be, one-sided and very much policy-oriented, and say, we don't want to interfere with democratic decisions of the states. Yeah, I think we still have the need to have a corrective in terms of investment arbitration. But I'll leave it at there because I think Adina has not said anything yet, so I think.
I leave the floor to people more competent in this area, investment arbitration. Thank you.
Would you all say that arbitration is still a viable tool for solving this type of disputes? Or would anyone like to comment on this?
Sure. So thank you very much for having me here. As Sorina said, I took a legal management position after enjoying a career of 13 years as a consultancy lawyer, specialized in energy, especially oil and gas, environmental legal advice, and real estate. And all of a sudden, I was in charge of hundreds of litigations and arbitrations, some of them with local area and some of them with partial international exposure. So basically, I was in a situation where I had to decide, especially on a local level, which was the best way to shape it and the best way to address it. And as Philip mentioned in the first point, it's true that for example, for the upstream side of the business, it's already a standard. It's already decided. Yeah, you go for arbitration in different forms, different shapes, different type of courts. Yeah, depending on the value of the claim, of the type of the project, and so on. But for national contracts and projects, it's most of the times, or at least it has been in my experience, more of a local decision or a personal decision. How do you best address it? Where do you feel that you have the best way to handle it? And from my perspective, for example, and I was happy to work with Cosmin Vasile here, who's looking at his phone, not hearing his former client. He has indeed helped me shape my view on the benefits of arbitration, and actually he has been an advocate for this kind of arbitration. We ended up including arbitration in most of our contracts, especially on the downstream side, because indeed, when you see the benefits and you see what it can get you versus regular courts, yeah, you decide it's a very good way. Now, of course, you can't say that it's a tool that will apply to everything. Me as a business lawyer, my view on the business and on litigation and dispute resolution as a general, and excuse me for being blunt, I would sit for days in a negotiation room to see something happen, to get a deal done. But the idea of handling a dispute after the parties, you know, don't no longer reach an agreement is like burying a dead corpse, you know. There's no fun and no excitement in that. For me, the question is, how do we handle this swift, efficiently, cost-effective, you know, and it brings absolute no pleasure. The pleasure in building something, not putting it on the ground. Yeah, and for this, yes, whatever it comes as a solution to get it faster done, so we can proceed to doing our core business, and this is the way for me. Whatever it comes, we have a contract, but if some sort of shape or format appears, and we both agree on taking that, we would probably take it. And in my experience, this is the idea of management, of business management. Yeah, for them it's an unfortunate situation. Yeah, they have to deal with it. But if they can get away with not dealing with it or handle it faster, most of them would agree. Nobody wants to say, I have handled for 16 years a litigation, or I've been the proud owner of a decider of an arbitration. Yeah, I have never seen it. Maybe they exist, but I don't think so. Yeah. So I think that
not in-house, but maybe with external.
Yeah. So I think yes, arbitration becomes more viable, but we're going to discuss probably later the conditionalities and the things that they have to comply in order to remain viable in terms of that. Thank you.
You mentioned earlier arbitration in comparison with other alternatives form of dispute resolution, and I think it's linking nicely to this topic.
I would just, of course, I mean, I would agree with what was said earlier by my very able panelists, but I would just add that maybe to answer your question in a long form is to say that yes, arbitration is definitely one of the most preferred means to resolve energy-related disputes. But as Adina has mentioned, I don't think it's a one-size-fits-all. And again, that goes back to the fact that a lot of effort should be put by users when, you know, structuring the deal. I think there's a misconception that often, you know, when the dispute arises, people then are inclined to sort of try and firefight the issue. Whereas I think, and namely for energy-related contracts, and namely the long-term energy contracts, such as in the nuclear sector, there's a lot of investments that are put forward over a very lengthy period of time. And we're talking about decades, actually. We're not even talking about a few years. And so definitely, I think there should be an approach or a dynamic that if arbitration is deemed to be the preferred means or the selected means owing to the multi-jurisdictional aspect or the multi-party aspect, the arbitration agreement should not be an afterthought. It should really come in handy at the time of the structuring of the deal. And that means as well that one has to consider, obviously, probably some of the inconvenient elements of arbitration, meaning joinder and consolidation in certain jurisdiction tends to be almost an impossible mission. You're not allowed under certain jurisdiction to join third parties or even to consolidate the certain types of proceedings. So this has to be factored in. Obviously, the place of ultimate enforceability as well has to be factored in. So it is definitely not a one-size-fits-all. When I was reading into, the preparation for this panel, I did notice as well that there has been also an extreme rise in the use of mediation. And this is something I have personally experienced at the very outset of the pandemic with respect to energy-related disputes. I had many of my clients come in and say, look, we do have an arbitration clause, but we're not really interested in that. We would really like to try and mediate this because it's not necessarily, costly or as costly. And it's not gonna cost us, a lot of time to do that. And who knows, maybe in 2 or 3 years, the party against whom we will be going against may actually be filing for insolvency or bankruptcy proceedings. So there's even that heightened risk that what you can get, the dollar amount of what you can get on your claim today is not necessarily going to be the one you're going to be getting, say, in 18 months or 2 years down the line. So I think, there is some form of probably a threat probably of other forms of ADR. I think that threat is mainly, in my view at least, illusionist, because I personally believe that mediation is a different beast than arbitration. It's not necessarily an adjudicative form. And a lot of psychology plays into whether ultimately a mediation can be successful or not. But I would also add that maybe what I think is currently the biggest threat for energy-related dispute in terms of dispute resolution is definitely the rise of the international commercial courts globally. And I'm talking about, some of you might be familiar, English-speaking commercial courts that are sitting there, around more than 10 globally, and there are a few actually sitting in the United Arab Emirates. Those are called the DIFC and the ADGM, and those are acronyms for Dubai International Financial Center and the Abu Dhabi Global Market. And those are English common law courts. Some of you may know that the official language in the United Arab Emirates is Arabic, and it is a predominant civil law jurisdiction. However, with the caveat that we often call and refer to it that it's a civil law ocean with common law enclaves or islands. And so those are common law islands in which the courts run in English language, applying primarily common law principles. And I would say that probably because of the heightened probably advantages of having probably the flexibility or the technical expertise that one would expect of arbitration, but also probably less costs, and the ability to join third parties or consolidate claims in a much easier stance than one can do so in arbitration, I would think that probably arbitration is going to be on the lookout for the rise of those international commercial courts.
Definitely, it should prepare for such things.
Absolutely.
Very interesting intervention. Thank you, Sarah. Ioana, you told me that you want to add something.
Just very briefly, because I think it's this panel is called Users Perspective, and I think we have to hear the users, so I don't want to take too much time. I wanted to build on what Sarah was saying about mediation, and your question was, is arbitration a proper or a suitable, viable solution? And my answer would be, probably that yes, but you should also think about adding mediation as a prior phase to arbitration. We see more and more in our cases that exactly what Adina was saying, the clients are coming and they want a solution. And so, I mean, I see us as dispute resolution lawyers more as solution finders rather than grave diggers, speaking of your dead body analogy. And I think mediation is really a very good point, although often you don't reach a solution on all points. But I think there are two issues which are really important, especially from the in-house. This is the return I have for our clients. The first one is that sometimes it helps solving some of the issues. So you reach arbitration with less pending issues that you initially started with. The second one is that you really manage to mobilize everybody in-house and get all the documents done, all the necessary elements before you reach to arbitration. And I excuse myself for the in-house here, it also shows very often your client that the impression they have of the file, which is that it's the best file ever, and of course they are going to win. When you're in a mediation, oftentimes it brings everybody back to earth, and it really shows what is the actual issue, but also what is your standing in this arbitration. So I think going through the mediation phase, in my experience, is only positive. And in certain countries, it is seen, and I see some of our clients from certain countries, they ask, aren't we going to look weak if we go to mediation and actually show all our weapons from the other party? Well, first of all, you don't have to show all your weapons, number one. And number two, I think everybody wants to find a solution, especially in these long-term projects. Our clients are interested in continuing the project, getting over the issue, and just continuing and finalizing the project. So mediation, thumbs up, Sarah. I'm totally for.
Before arbitration.
Before
not
arbitration.
Instead.
Well, I hope instead for our clients it's better if you start and find a solution, but oftentimes it's not the only possibility, exactly.
Thank you very much. But where these disputes arise from? Always from the contract. Mediation and arbitration have to be agreed also in the contract. So in this market where we are, what would you say that, and we heard Michael earlier today saying that most of the disputes come from the poor drafting of the contracts. What would you think it would be necessary to do, or what recommendation would you have for drafting of contracts?
Yeah, another
Maybe I'm
another
wrong.
good question.
Maybe it's not coming from there, but yeah, what it is your view?
I'd say not necessarily, strictly from a contractual perspective. A contract, the perfect contract is never read after it is signed. And we've, in my work, I've heard that and actually seen it at work a couple of times. Nonetheless, the contract is in terms of wording is as good as the actual situation was explained to the writers and was understood and perceived by the writers. I don't think there's a sort of perfect contract. And therefore, I'd say that actually arbitration arises not necessarily from, I don't know, poor wording of a contract or certain gray areas or missing clauses, but rather the sort of lack, I'm trying to avoid the word predictability, the lack of a sort of clear match between the intention of the parties at the time of signing of the contract with the foreseeable future during the lifespan of the contract. And that's especially important in, let's say, energy related contracts, because they have a sometimes, as mentioned, they have a very long lifespan. They involve a lot of stakeholders. They are, many of them, technical or super technical in their nature. Some of them are even signed when a technical solution does not even exist at the moment of signature, and there are facilities to be built and the solution to be further on implemented. So I'd say once, as long as working with professional engineers, business people, lawyers, I think we're good on the contract side, but that's not a guarantee that an arbitration will not arise, and therefore, as I said, I think it's more on the parties' interests and approach whether an arbitration actually arises or not. And yeah, actually, I remember something. Probably I should have mentioned at your first question, is that actually some of the most interesting arbitrations I've seen in my life are those that never happen. They were about to start, or there were some discussions around it, and they were super interesting. I mean, just watching it unfold purely from a lawyer's perspective would have been great. But they've never actually materialized because either predictability and stability gave the parties the right solution, or the parties had actually common interests into moving forward.
Thank you, Philip. Adina, would you have a perspective? You have shared the same sector of industry.
Well, I think that, of course, as a business lawyer, I think the contract drafting and execution is the most important phase. As Philip said, I don't think there is an ideal or perfect contract. If somebody can show that to us, I'd be very happy to see it, but I've never seen it. in the oil and gas sector, I think that the industry is heavily regulated. So, and also we have a lot of technical, let's say, expertise and technical drafting of what it is and what is not said. And you don't really account for errors, you know. As Philip said, you know, you have a lot of engineers, a lot of project, they know what they're doing. You know, they're not going to ask you as a lawyer what their job is. They know it very well. But I think that the most important thing that you do at the signing of the contract is basically, besides having a consultancy lawyer and a litigation lawyer looking at that document, because the perspective is quite different, and you need to have it at the onset, not at the end when you already have the problem. Yeah, I think that the most important thing that you do as a legal team, both internal and external, is to make the risk assessment. You know, you look at the overall market, you look at the situation, you look at the trends, and as Philip said, you look at short term, medium term, long term, depending on the type of project. As we discussed in the breaks, you know, and as Alina pointed out, can you look at an energy project where, without saying, you know, any element of politics is involved? No, you cannot, obviously. It's a strategic field. You always have, you're going to have a lot of developments. And therefore, this risk, that you make a risk assessment, is a moving target. We see it today with Ukraine, yeah? Yeah, who would have thought like 5 years ago? Like nobody would have thought this is possible, yeah, in Europe. So, but at the same time, you know, you have to be conscious that this risk assessment that you're making is not going to be perfect. I mean, you only have the variables that you can assess at that given point, and based on those, you have to make a decision, yeah? And of course, if you are in a 30 or 40 years contract, you know, those will vary a lot. And I think this is where, in the execution of the contracts, where you have disputes, you know, because you have some realities that have changed, not because you put a thing from A to B or C, is like, you have industry practices for that. It's because the fundamentals on which you based your relationship kind of changed, and for this you have adjustment mechanisms or you do not. And this is what I've seen. This is how I see it, yeah? But you do need to make that risk assessment correctly in the beginning, because sometimes the risk assessment is made badly, yeah? And in my experience, this is what I've seen. Things go wrong, not because of something, it's just because you did not pay attention. Thank you.
And sometimes, more than this, all the parties and all the stakeholders are so enthusiastic and willingness to do a project that they sign the contract that all the lawyers saw. And then, okay, it has some problems and something occur. And the big dream to have that fantastic arbitrage is also stopped by the same parties and the same stakeholders who are deciding in a way or another maybe not to go further with this fantastic arbitrage that we see as lawyers, all that we were also involved in signing the contracts.
Ioana, if you'd have to, thank you, Alina and Adina.
If I may, I want to add a couple of things to that, because I think it's just a fascinating topic, and I've seen many panels where lawyers or attorneys would sit there and talk about pathological dispute resolution clauses, which they are, and they would like, oh, look at those in-house counsel, they don't know how to draft. And it's the question for me, or in my experience, we have pathological clauses in dispute resolution, and I think there was a lot of wisdom in what Michael said this morning, also, or earlier on, about, you know, the escalation clause going from adjudication or dispute boards or to arbitration. There are always problems, or not always, but many problems with that. But in my experience, and I think this dovetails with what Adina has said, is many problems arise, first of all, in contracts with respect to the delineation of scope. And I think that's for construction and energy projects the same. And others arise from contractual procedure. So, and this is maybe something that when you ask the question of, you know, what would be your recommendation on how to approach this, what I've done a few times is I would go with the parties, go to a flip chart or whiteboard, and maybe just draw a picture of the dispute resolution process, or a flow chart, or maybe not just the dispute resolution process, but also the, let's say, notification process for variations and for delays and so on, and see how it progresses through the contract. And if you do that, you sometimes get both parties saying, oh no, that's what we said, that's unrealistic. 14 days to notify that? No, no way. Yeah, and I said, okay, let's do it better then. Then we don't arrive at those clauses where we have to fight. And I think that's one of the things that really worked for me, for example.
Thank you, Florian. Ivana, if you have to offer some tricks and tips, what would be in drafting the contract?
Well, I think what Adina is saying about the risk assessment is absolutely true, as long as you are facing things that you can assess or which are foreseeable. What I'm interested in a lot these days, because our clients are asking a lot this question, is how do you deal with, contractually speaking, with unforeseeable elements, and how can you, contractually speaking, add clauses which allow for a readaptation of the contract and also risk allocation which is fair, and which also allows the contract to continue and the project to continue. And in that sense, I want, we all have, as we work, periods of time when we are obsessed with something. My current obsession is the hardship clause. And it's the hardship clause because I think there has been mentioned in the panel before, the force majeure clause has been mentioned. I think we all know what that is. It makes the performance of the contract impossible. Well, currently when we look at what's going on in the world, it's not that the performance is impossible. It's just that it is delayed, it is more expensive, it is more difficult. Hence my obsession with the hardship clause. There has been a lot written about it, and I'm far from having read everything, of course, but as just for maybe as a word of introduction, hardship means that the performance is made more expensive, or that there is an imbalance which is created between the parties by executing the contract as it is. And actually, termination of the contract, it's only the ultimate solution in case the hardship clause didn't allow the parties to renegotiate or to reassess the position of each of them. So I think that this is what one of the tips, if I would have to have one, would be really to all of us go back and read into the hardship clause. It is a very technical clause because you have to assess for a number of different issues. One of them, for example, is what are the triggering effects and what is the thresholds. What is the moment in which you decide that you're entering into the hardship clause perimeter. But there is also you have also to assess and to put in the clause what are the arrangements for renegotiation, what is the framework for renegotiations, etc. So there are a number of elements. I'm not going to talk about all of them. We wouldn't have the time. But I think this is really one of the points where we all have to look into, and we will see a lot of that in the future, the hardship. The other element which I've seen a lot discussed by our clients is the price adjustment. When you talk about raw materials, how do you put a price adjustment clause which allows for the different changes? And actually, one of them, what I see more and more, is the indexation of the price adjustment, indexation on the prices on the stock exchange, for example, the stock markets, stock market. So that's also one of the clauses I think we will see more and more, price adjustment and indexation one. And then something which I've seen just last week, and I wanted to mention very briefly, is the concept of best efforts and reasonable efforts. This is something which, again, there is a lot of literature on that. I think that parties will more and more go towards reasonable efforts rather than best efforts. You also have the concept of commercially reasonable efforts. There is a lot of work to be done there by arbitrators in interpreting what that means. I think English law is a good source of inspiration for that. But there is a difference between best efforts and reasonable efforts. And when trouble comes, you wish you put reasonable and not best, of course. The only tip I would have there is that you have to make sure whatever you go with in a contract to stick to one of the standards throughout the contract. We currently have a dispute in which on the one hand you have reasonable and in another clause you have best, and of course it is difficult to argue that the party's will or intention was to go for one or the other. It's a bit difficult. So if whatever you choose, just try to be consistent throughout the contract. That would be, I think, these would be my points on that. And I just wanted to answer indirectly to Cornel's point about inflation earlier. I think this is really something which we will see a lot, inflation cases. And I was just reminded by reading that in the Argentinian cases that were happening in ICSID some time ago, especially in the CMS one, there is some very interesting developments on inflation. And I think there will be also in the future quite a lot.
Thank you very much, Ioana. You mentioned earlier the concept of reasonable efforts, which is linked to good faith. Do you think that and the fact that the arbitrators will have a lot of work to interpret and define these concepts in the future, any of you think that good faith and equity will gain more and more field in the work of the arbitrators in this particular sector in the future? Anyone?
I mean, I have a view on that. I think that, first of all, good faith. I mean, in certain legal orders, like at least the French and the Dutch ones, good faith is actually a thing. It is in the civil code. It is a public policy, and you cannot just get around with it without applying good faith. So, is this a thing or not? Well, yes, in certain jurisdiction, it is a thing, and it is actually a public policy element. Good faith. Now, I think the difficult part as an arbitrator is that, and also actually as parties, is that with everything changing, or at least unforeseeable situations, is that you gave your consent to a contract on a certain situation with certain elements being there. Now, what happens is that at a certain point in time, those elements on which you gave your consent have changed. So the question is, I think as an arbitrator, but also as parties, do parties have the intelligence and the courage to say at a certain point, we want to continue the contract? And actually for that, we have to admit that the circumstances are not the same anymore. Now, equity is problematic because I was speaking about public policy before, and at least in French law, you cannot assess inequity unless the parties have expressly given you the possibility to do so, at least under French law. So
it is the same under the Romanian law. Okay. And as Florian mentioned sometime, please, Philip. Yes.
No, I just wanted to throw another term into the soup, which is prudence, and I think I've seen it in a couple of cases, and I think it will happen probably more and more. That arbiters would have to look at the prudence manifested by a party in the execution of a contract, even when circumstances have changed. And we've seen cases even in Romanian that there's one thing, prudent behavior of a party into, for example, securing sources of energy, gas, electricity, and so on. And there should be another treatment of non-prudent behavior of a party, just going from 5-day, 7-day contracts from one to another, trying to to chase every penny, rather than securing a stable position. That was it.
Thank you, Philip. Florian, you mentioned earlier in our discussion in the breaks about the legitimate expectation, and I think it's linking very much to the subject of changing circumstances.
I think that's really now becoming a rather tasteful soup, because that's another related topic or related terminology that plays into that role. First of all, let me say, also under German law, good faith is very much a thing, and therefore there's less fear also for us to be dealing with that. We used to be dealing with that particular thing, and I think it is in the context. And since Ioana mentioned the challenges for arbitrator, I think it's very true, specifically with those terminologies which will have a wide berth of interpretation, like, for example, good faith, but also like hardship, because I don't see the issue so much with defining them in legal terms, but supplying the evidence in international arbitration and also in investment arbitration for legitimate expectations, yeah, to the standards of evidence that are, for me at least, well, although I'm not an expert necessarily, but for me, not yet quite clear. And I think that's going to be the real challenge in the environment that we are in when we're talking about hardship, is to understand what are the benchmarks for that. Yeah, when I say, well, I've entered into the contract expecting vastly different circumstances. Why? I mean, we have a very volatile environment, and we had that for some time, and we had that with COVID, and to, let's say, manufacture some kind of stability, artificial stability before, just to have a comparison or reference point for saying, oh, well, I didn't expect that. That's going to be hard to prove. And that's what I tell my internal clients. I said, first of all, first thing I tell them is, you talk force majeure all the time. Sorry, it's hardship. Yeah, with this, the discussion we have, so I know that discussion. And the second thing is, well, what did you expect? You know, what, and by the way, when you look at it from a German point of view, we call it Störung der Geschäftsgrundlage, which means it's a disturbance of the basis of the economic equilibrium. It has to be manifestly big, this disturbance, yeah, or this interference, in order for you to be able to say, okay, now we're talking, now we need to adjust and maybe even terminate. So that's, I think, long story short, that's going to be the real challenge for tribunals, for counsel, and for the clients to, you know, to supply and collate that kind of proof that you're able to say, yes, it was so vastly different from what I expected. And I think we've seen that with legitimate expectations in many investment cases before, that this is the crux. Yeah, it is sometimes even the crux when it comes to, you know, proving your case. It is almost always the crux when it comes to quantum. So I think that's going to be much more in the future.
Well, legitimate expectations is my other obsession, so don't get me started. But if I can put the two parts of the table together, meaning what Philippe was saying about the fact that you have to make all the efforts in order to minimize, in a way, the impact on the contract, sorry. And on the other hand, what Florian was saying about keeping all the trace of everything that you've done in order to do that, and what can you prove? I think this is really, as a counsel, this is really the difficult part, and this is what is the difference between being saying that an action is negligence and saying that you did take all the measures. What can you prove? What is the proof that you have in-house that you did take all the measures and that you tried to minimize the impact on the contract? And we will never say enough to our clients that you do have to keep trace of every single action that you take, and this is ultimately what will make the difference. And good faith is also part of that. If you really tried try your best, sorry, to minimize the impact, it always comes down to what can be proven, clearly.
Your best or your reasonable best?
Sorry?
Your best or your reasonable best?
Exactly.
Yes, and here I want to say that I want to put also a word on the table. It's simplification, because I think the user, in fact, is the business, and they hear about reasonable best, this lawyers' terminology that is too much, and they ask for the legal teams, external, to simplify everything. So maybe simplification should be also on our list when we speak about these sophisticated clauses that trigger a lot of problems for the arbitral court. Maybe if we simplify our thoughts and our clauses, maybe it would be easier to get a solution and also faster.
Thank you everyone. I would move from prudence to predictability again, and I would like to ask every one of you whether you consider that in this long-term energy contracts, considering the recent developments, the user's obligation in arbitration are or should be maintained. And I would invite Sarah to share with us some thoughts. And Philip. Sorry, and Philip.
I mean, I think we would all agree that we live in extremely volatile and tumultuous times, at least since March 2020. And the recent events in Ukraine have unfortunately not necessarily helped the situation. But I would add to that, and maybe to put in a little bit some food for thought, that back in the 1971, the price of crude oil was standing at $3.17, so that $3.17. And currently, as of today, oil is trading at 123, and just a few minutes before this panel discussion, it was exactly trading at $1.2358. And over the past 12 months, there has been an increase of 70.83%. And since January of this year, there has been an increase of 58.31%. Now, that is obviously whooping figures. And obviously in contracts which are perfect, which I think all of us tend to agree that they actually are non-existent, this can be very easily remedied for. But especially when we're talking about consensual mechanisms for dispute resolution in the context of energy, and I would even say long-term energy contracts, there's a very intricate issue which arises even before we take a step ahead and talk about the evidence and the burden of proof and even the applicable standard of the burden of proof, which is to take a pause here and try to understand whether actually the arbitrator is empowered or not, or has the authority or not, to step in and intervene in what was actually a contractual private arrangement. And in doing so, whether there's a duty on the arbitrator to step in, and what is the source of such a duty, and what is the scope or the contours or the limits of such an exercise. And I would spare you maybe probably the over technicalities and the debate that's happening, but for the most part, arbitration laws globally do not factor that in, at least not explicitly, save for two jurisdictions, and one of them is because it was cited earlier, is the Netherlands. So this is what we often refer to as the Dutch exception, and I'm referring to Article 1020 of the Civil Procedure Code in the Netherlands, which allows explicitly for arbitrators to step in and fill the gaps and even adjust. And this is quite interesting because absent such a statutory procedural authority, this would mean that parties would have to pretty much give the authority to the arbitral tribunal to do that, and that can be either embedded under the substantive law or, and I've seen it in cases, embedded explicitly, for example, in the terms of reference. And that would mean thereafter, once we've checked in the box, because if there is no authority, then that would lead to disastrous outcome, which means that the arbitrator would be going over and above what she or he should have done, and that could lead to set aside of the arbitral award. And ultimately, when you're looking at what needs to be done really to step in, we've talked about earlier on the hardship or the théorie de l'imprévision, which is prevailing mainly in the civil law jurisdictions and also in the Islamic law jurisdictions such as Saudi Arabia, for example, and is premised upon duties of good faith and duty that the contract derives itself from social justice, and as such there could not be an imbalance of the contractual equilibrium so that to reach a stage where could be tantamount to an abuse of contractual rights, hence a requirement for a step-in. And what is quite interesting to note is in certain jurisdictions, such as, for example, the United Arab Emirates, it is not possible to actually contract out. So in the same line as, good faith and the public policy aspect of it, a hardship or imprévision is also deemed of a public policy nature, which is often confused because when you have long-term energy contracts, and it is unfortunately quite the case in the Middle East region, often these contracts tend to be sometimes drafted by English qualified lawyers. And then you end up having a mix of English concepts with ultimately trying to add to them certain facts which would not necessarily be the ones to be ultimately received in the context of civil law jurisdictions when you are seeking to apply substantive law, which is a law from the Middle East region. And often you will find, for example, force majeure clauses, which for the most part are not deemed of a public policy nature, and therefore parties have more of a liberty in adjusting and defining what constitutes or not of a force majeure. Also being, I would say, misapplied equally by civil and common law tribunals, which means that ultimately when you're standing before an international arbitral tribunal, which means that for the most part, you're getting hybrid tribunals with arbitrators, especially when I'm talking about 3-member tribunals from the common or the civil law jurisdiction at once, it is very critical at the time of the drafting and the preparation of the agreements to also account for clear definitions of what would constitute the triggering event for a hardship or imprévision, and equally the force majeure, because, and more importantly, I guess, the legal effects of those. I recently was involved in a case which was a long-term supply of energy contract. And what ended up happening is one party pleaded at the same time imprévision and force majeure. And as Iona has mentioned, force majeure means basically there has been an impossibility in performance, whether total or partial, which leads to the termination. It's not the case of imprévision, which means that there has been an overly burdensome performance, which means that there should be room for adjustment. And the arbitrators in this particular case ended up actually acknowledging the overly burdensome nature of the event and the impact it had on contractual obligations, but actually instead of adjusting them, they ended up pretty much terminating the contract, which is pretty much a cherry and pick and choose misplaced exercise between what would ultimately happen. So,
but sorry to question, was that in the prayer for relief, the termination?
So the parties have pleaded mainly the imprévision, due mainly to the pandemic. And they have also equally pleaded force majeure. And what the arbitral tribunal ended up doing is cherry pick the triggering events, qualifying them as imprévision. And instead of applying the legal effect for imprévision, which is to adjust the contractual obligation, they pretty much took the one arising of force. So it was pretty much a cherry pick selection exercise. And the same would come into play as well with regards to the application and adjustment of liquidated damages clause. And again, we see a lot of movement as well and divergence between civil law tribunals or common law tribunals. So all in all is to say that going back to predictability, international energy players definitely want certainty and predictability. And so that comes in again at the user's level as to trying to mitigate at the outset, even though we're talking about disputes here and the fact that, you know, dispute has already risen. But I think, you know, as a disputes lawyer, I would always tell my clients that even though it would be definitely my preference to take them to an arbitration and dispute this all along the way, I think it is sometimes important to actually, one, structure the provisions appropriately. And as was said earlier today, I mean, the pathologies would only overcomplicate as well the resolution of a dispute, and that doesn't necessarily help. So maybe just to close down is arbitrators can and will do basically whatever was asked from them, to the extent, of course, I mean, there are always outliers, but there has to be also extra careful weight given to those statutory or not provisions afforded under the governing laws.
Thank you, Sarah Philip.
I'm cognizant of time, just to quickly add on something. So clearly the predictability in the context of arbitration is has practically three elements: tribunal, legislation, or applicable law, and jurisdiction. And I want to link with what Sarah was saying. Pandemic and in our region, war in Ukraine has clearly changed the energy landscape and the landscape in general, especially the pandemic. What we are, maybe as an insight, what we're feeling or seeing is that we've seen parties in or players in energy in the past a bit more litigious, but that that was triggered not by a clear necessity or I don't know, state of emergency or risk to the business and so on. That was triggered by more or less, it was, kind of common practice. Yeah, where's our interest? You do a delta on the financial impact and you take a decision. What we've seen later on, although especially certain actors are heavily impacted by events like pandemic or war in Ukraine, there is also this, I don't know how to call it, a tendency to try to find ways to move forward, to on both sides, to work out this unpredictable situation that has arrived, to be more transparent of the causes, I think that's in this regard, when this doesn't happen, maybe mediation could help. Although on the mediation side, I'm a bit reserved, especially on the in large-scale projects or projects that have a quite considerable value. Thanks.
Thank you very much, Philip. I would not like to close. We are closing almost in 5 minutes, but I would not like to close our session without discussing two very important issues which are linked together: sustainability and digitalization. So I would like to ask you all, how do you see the future of arbitration? Do you see the arbitration as being sustainable, and why and how? And how do you see the digitalization interacting with the arbitration? Who would like to start?
Maybe I will say a few words, because I'm working for a company that is fully dedicated to technology. So seeing every day that it's about platformization, about digital virtual grids, about using the space, I think it's important for the legal teams and also for the arbitral procedures and everything to be connected to this reality. Even though we are traditional and we like what we are doing, we like the traditional way of learning, reading, using pencils and everything. And coming back to the work simplification, I think the user and the business in parallel with this digitalization is trying to obtain something faster, cheaper, and simplified and flexible. So in this way, I think all the legals should be adapt somehow to this, and we don't have time to wait and see, because it is as we see in the last years, every time it's something, it's an emergency, so we have to move, we don't have to postpone and reschedule. It was fantastic that COVID brought a lot of openness to digital, I don't know, drafting electronic documents, not using traveling so much, seeing that it's possible without maybe traveling or without using paper. And in this way, because you are speaking about sustainability, we see the environment impact. And of course, we can use also platforms that are more secure from the technical perspective, as business is doing. And if we are speaking about sustainability, I would mention also education, that maybe sometimes we are not so open to these technical solutions because we are not trained in this respect, and we are used to use books and everything, and maybe training at all levels, including the schools, should be a point, and also partnerships. Partnerships for goals, it is one of the UN sustainability goals, and I think this is somehow what is lacking in our profession, maybe to have partnerships with different IT companies, software companies, and step by step trying to understand that this is the future, and okay, it will not be about us lawyers not being there, but being helped by this kind of tools that can use data, can come with the, I don't know, some advice that is issued by a smart robot and everything that we hear all day. And for this, we need this kind of partnerships and not stay like in legal family. We have to go out a little bit or open a door at least.
You open the door also for another interesting discussion, artificial intelligence, which is a different animal altogether. So Adina?
Yes, thank you. So I will be short because we're running out of time and because the other speakers in the panel have to put their point of view. I would start by saying that, and I view this sustainability a little bit different from what law firms have been saying about, you know, getting greener, not printing too much, which I think is, you know, just like 0.1% of the issue. But I would address sustainability at large and at arbitration in particular by starting with a quote from Simon Sinek said recently in a podcast. He discussed the difference between the act of listening, which is basically that your ears work, and the art of listening, which means that you leave aside your prejudice and your ideas and your experience and you actually listen. And what I can tell you is that as a legal manager, I've always enjoyed working with lawyers, irrespective of their experience, who came into the room and actually listened to your ideas. I mean, looking around, we are a lot of people here with 10, 20, 30 years of experience, you know, and we tend to think that we already know what's the issue, you know. We know it, the client doesn't know, but we know it, yeah. Some of us also think that we're God's gift to the profession, yeah. We probably are God's gift to something, but we never know what it is. And I think that in this state of not listening to the needs is where we start making mistakes and sometimes not being chosen as a counsel or, you know, for the particular project. What this has to do with, say, sustainability. I've listened to I was not here from the morning, but I listened it online to the conference, and there was a beautiful, let's say, discussion on various topics and various small points, you know, as a legal specialist. But I think if you zoom out of that and you look a little bit and you come back to what we discussed before as how do you make decisions as legal managers, irrespective of your budget, irrespective of your size of the company, what I can tell you, and I'm sure it's not only my perspective, is that if tomorrow there is a way to litigate, arbitrate, mediate, you know, with half of the cost, you know, you're going to take it. Management is going to, nobody wants to burn the money to give 1 million when they can give 500,000. How does this address you? The world around us changes. You know, we hear discussions, well, can robots and artificial intelligence can take our perspective? Well, yes, they can. And Alina and Philip and I discussed in various other contexts these issues. And people say, you know, no, they can't take it. Well, I think they can. The question is the percentage. Some people say it's 10%, some people say it's 20. I think it's over 50. And I think also at this level of globalization, at this level of standardized contracts or activities, you know, that is going to take a little bit more because I've seen international lawyers handle local projects brilliantly, like brilliantly. Yeah, I mean, if you're a EU lawyer, you're probably going to do like 80% well in a lot of the jurisdictions on a general issue, not only, yeah. What has to do this with arbitration? Well, let's look a little bit. I mean, arbitration was going well, and it was preferred after the Second World War, yeah? And the rules went well, and so on and so forth. But in this context of digitalization, in this context of generation, will it still be applicable in 10 years? You're talking about people right now, they're 20, we're 25, we're developing business, the growing companies. Will they look at us dinosaurs and say they will still want to see us? I do not think so. I'm recently taking this capacity as teaching students, and I can tell you, they don't care who you are. If it's relevant for them, you will be there. If it's not relevant for them, you will not be there. So you see a specialist and we see as arbitration as being very nice. And I can tell you that from the outside, it can look really stuff and really formalistic, not as formalistic as courts, but really formalistic. And I think that you as practitioners and as a profession have to still take a look at it and how can you simplify it, as opposed to what Alina was saying, is whether you take a filing online or you can take, I think that's just the first step of the process. Yeah, and I think that you cannot do it individually. I think you have to do it as a profession. You all have to perform the art of listening and go back to your clients and ask them what is relevant for them in the energy and other industries, and then go back together at your table and how do you make this art of arbitration relevant and alive in 10 years from now? Because I don't think that for example, some tech guys, looking for a solution will really want to get stuck in a 1-year process and filing of thousands of documents when they have an alternative. If they can develop in 6 months a robot to go through those documents, they will prefer to do it rather than give you money. This is my intake on that. And that, I think, it goes for a lot of the processes. So, and I think this is not necessarily for arbitration, but I think it's for the legal profession at large, because we say we're irreplaceable. Yeah, some of the points are, yeah, the legal judgment, the input, but not all of them. So we really need to think about what the future is and where we want to stand. Yeah, thank you.
Thank you, Adina. I really hate the moment when other people would look at each other at dinosaurs and will prefer to interact exclusively with the machine. I hope to never live that day.
Well, sorry,
but it is a reality. So digitalization is a reality that we cannot ignore. So I give you that. There are a lot of operations which everybody would prefer to be done by a machine, like filing documents and searching through the documents and browsing and things like that. But definitely there are some operations that I would never prefer a machine to take a decision.
I was shocked. I read Malcolm Gladwell's book, Talking to Strangers, and I read that study done by this Harvard scientist with some computer guys and said, in bail analysis, the computer and the machine made a 25% better analysis than the judge, who thought, I'm looking into the guy's eyes and I will determine better based on my experience whether he is going to commit another crime. You just have to look at facts, and the facts, unfortunately, are not in our favor. Or to say that bail is going to go better if the judge ate, it's like, come on,
Take that you're very passionate about this subject, so I will not go further.
I just want to really second that what Adina said, meaning that to put this digitization and sustainability in a broader context of what we are facing as a legal profession right now. And I think that the essence must be, and I just want to give one example, because I was involved in 2018, because it has a bearing on arbitration, I was involved in revising the rules, arbitration rules of the German Institution for Arbitration. And basically what our task was, metaphorically speaking, say, go and draw a circle. Here's a square. Go and make a circle. And we came back and we made a square with little round corners. And then we celebrated ourselves, saying, oh, we're really good because we made this procedural step much easier and this procedural step much easier. Whereas for the clients, it was like, well, you basically doctored a little bit on a procedure that actually is maybe sometimes falling out of time. You need to be a little bit more creative on addressing that. It's like saying,
the client thinks, well, I need a hole in the wall, and you go, well, I have this beautiful drill, and it's got this button, and it's blinking here, and blah, blah, and the client says, well, nice drill, but, you know, I need a hole, that's all, you know, and if you want to have a hammer and a nail and make a hole, and that works for me, then do that. I don't need all the buttons on your drill. So I think it's really a good point to say, you know, we need to, and that this goes for document production, how you use artificial intelligence. This goes for online hearings. This goes for, you know, all kinds of things that don't necessarily relate to technology, but the way we approach dispute resolution as something to resolve and not something to, let's say, a procedure to celebrate, you know. That's, so I very much agree with you.
Ioana, Alina?
Fully agree with Florian, and I think that the best words are, let's use our talent and knowledge on the merits, and let's use artificial intelligence on administrative stuff in order to have enough time to focus on what is important. And it's impossible as us lawyers to stay, let's say, not so open to these technologies when we see telesurgery, so long distance surgeries like Zeus robot. So it's about the health, and it's a matter of life and death, and is possible. And before coming here, I was reading an article. A computer algorithm was appointed in a board of directors. In the same time, I was reading that the directive for equality in the board of directors was making steps after so many years. So as we like or we don't like, it seems that things are going very strange. We see equality, but we're seeing also algorithms that are going in this direction. Okay, maybe it's not the best idea from many points of view to have an algorithm that is taking decision in the board of directors, but it is happening. So why not also in the courts of arbitrage to do something, maybe on the administrative stuff, in order to cut these terms and have the business more happier when you see that it's not about 3 years, but it's about 1.5 years. So this is from my side.
Anyone else?
Well, I'm asked by the chair to say something optimistic, and that was exactly what I was planning to do. I fully agree on the use of artificial intelligence to make things quicker, to look for documents, etc. But I just wanted, as a last point, to tell you that a quote by Gaspar Koenig, who is very famous in France these days, and who says the following: "The risk is not that much computers with artificial intelligence will become like human beings and replace us, but that human beings, by relying on artificial intelligence, become like computers." So just to say that I think we were talking about reassessing, we were talking about rebalancing, we were talking about the importance of arbitrators in all these elements, and I think that, fortunately, is not going to be replaced by computers. So we as humans still have, and as arbitrators, be it combative counsels or excellent arbitrators, still have a long life in front of us.
But we have the white paper issued, and human centricity is there. So let's hope it will be human centricity.
Thank you very much for staying with us. Thank you to all the speakers in this panel for the interesting views that they share with us. And with this, I will close this panel. I will invite you all to join us tomorrow morning, because we are also having an interesting debate in the morning in relation to the investment arbitrations. We have one panel dedicated to investment arbitration and also one panel dedicated to Energy Charter Treaty. So both those topics are hot topics, and please join us. And in the afternoon, we have Young Romanian Arbitrations Association meeting, and a very interesting panel dedicated to interesting issues at hand. So please join us tomorrow, and thank you for staying with us until this late hour. Thank you to all of you.